Good morning, Acting Justice Bilchitz.
Morning, Chief Justice Sondo.
How are you this morning?
I am a little nervous, but I am also deeply honored to have had the opportunity to act at the Constitutional Court. I'm deeply grateful to you, the Minister of Justice, and the President for that opportunity and to be able to be present at this august hearing today. And how are you, Chief Justice?
Well, I'm fine. I'm fine, and I think I speak on behalf of all the commissioners too when I say they are also fine.
Glad to hear that.
Thank you very much for availing yourself for this interview. I just want to mention that Acting Justice Bilchitz is a professor of law, of constitutional law at the University of Johannesburg, but is currently acting as a justice in the Constitutional Court, having started at the beginning of February. He is still acting there. Maybe I should just explain a few things for the benefit of everybody. It is the first time in many years that this body interviews an academic for a position in the Constitutional Court. It hasn't happened in many, many years. So Professor Bilchitz is therefore making history, being the first one after so many years. This, of course, as all commissioners would know, happened as a result of a decision that was taken last year to open the pool up to senior practitioners and academics to be given acting appointments on the Constitutional Court so that they could make themselves available for consideration for appointment to that court. So Professor Bilchitz is one of the first academic who made himself available for that. And we thank you for availing yourself.
Thank you, Chief Justice. It is a great honor to even be considered for this position.
Yes. I am going to ask you questions, and after I've finished asking you questions, then the Minister will also ask you questions, and the President of the Supreme Court of Appeal and other commissioners who might have questions to put to you will also do so. In asking you whatever questions we are going to ask you, we are going to bear in mind the selection criteria that this body has previously decided would guide it in selecting candidates for appointment. Everybody who is here is just here to try to do the best they can to make sure that the selection process goes properly and fairly. There is nobody who is here to try and humiliate any candidate. Some of the questions might be tough, but that doesn't necessarily mean that anybody seeks to humiliate any candidate. So we will ask you questions that really are aimed at seeing how you satisfy the various selection criteria. You understand?
Yes, thanks, Chief Justice.
Yes, okay, all right. Now, I've already said that you are a professor of constitutional law at the University of Johannesburg, but you studied at the University of Witwatersrand many years ago, where you obtained your BA honors and LLB. Is that correct?
Yes, Chief Justice. In fact, I started my studies with the advent of the new South Africa. And so it was an extraordinarily exciting time to be studying law, where the first judgments of the Constitutional Court were coming out.
Yes, yes. And after you had obtained those 3 degrees, you proceeded to the University of Cambridge, where you obtained your MPhil and PhD. Is that correct?
That is correct. I did in between. I clerked at the Constitutional Court for then Deputy Judge President Lange, who became Chief Justice, as we know. And that was a seminal experience of mine and a great privilege to learn from Justice Lange and to really experience what the greatness that he exuded, the humility, the tremendous sense of commitment to social justice. And he has had a huge influence on my life, and in fact encouraged me to pursue my postgraduate studies. When I was, after a very difficult master's year, I was debating whether to come back and to go into legal practice. I wasn't entirely sure where to go. And Justice Lange said to me, "David, take your time, study. You will come back with more knowledge, more understanding, and you'll be able to help South Africa more rather than stopping at this point." And that led me to continue my PhD and graduate with that, which led to my first book.
Yes, I take it that you don't intend to demote him. He was Deputy President of the Constitutional Court, not Deputy Judge President.
Apologies. Of course not.
How long did you clerk at the Constitutional Court? Was it 1 year at that time, or was it a different period?
Almost a year, Chief Justice, around 9 months, because of my, I received a scholarship to study overseas, and Justice Lange said that I should go and study and not delay that. So he was very kindly released me from the last 3 months.
Yes. And you, after finishing your PhD, you did lecture part-time at, was it at Wits or Pretoria?
At the University of the Witwatersrand,
Yes,
mainly in the area of jurisprudence and philosophy of law.
Yes. Just to go back to the time when you did your first 3 degrees, it was 1996. That's when you got your BA, and then your BA honors was 1997, and then your MPhil was BA honors was 1997, LLB was 1999, MPhil was 2001, and PhD was 2004.
That's correct, Chief Justice.
So you, to get to the PhD, you studied for about 10 years if you start from BA.
That is correct, yes.
Yes.
A long period of study.
So altogether, you hold 5 degrees.
Yes.
Yes. Okay. Now, when you were at the Constitutional Court, how did you find the experience of clerking at the Constitutional Court, and how much did that experience help you in maybe deciding what you may have wanted, what you may have done for your doctoral thesis?
It was a seminal experience, Chief Justice, and I think one of the major contributions that the Constitutional Court has made is in the clerkship program, in nurturing lawyers who come out of university or perhaps a postgraduate degree, giving them experience of some of the most complex issues in our constitutional order. And then they have the opportunity to go into practice and actually, I think, generally imbibe a commitment to social justice from that experience. And my experience, it was an extraordinary coming out of law school and coming into the highest court of the land with some of the most exciting issues. And in fact, one of the cases that we engaged with was the Grootboom case, which of course is a seminal case in the history of South African jurisprudence around socioeconomic rights. And that case, because I wasn't exactly entirely happy with what the court did in that case, that led me to further studies in both my master's and my doctorate. And it led to my first book, In Poverty and Fundamental Rights, giving expression to both a critique of what the Constitutional Court was doing, but also trying to provide an alternative approach that I would give better expression to socioeconomic rights, in my view. And so, as you can see, having been at the court gave me a real sense of one of the critical gaps in both academic literature as well as jurisprudence worldwide. And that led me in a certain direction around my academic career.
No, thank you. But you went and did articles in a law firm, is that correct?
That's correct, Chief Justice. I wasn't entirely sure. I had been studying, as you say, for a long time, for 10 years, and I kind of felt law had a practical element to it. And I wanted to experience that practical dimension. I wanted to see law in action in many ways. And so, but I also wanted to combine it with my interests in relation to addressing the serious legacy of poverty in our country. And so I went to a law firm that did a lot of work with the government and that did a lot of work about expanding services across the country, particularly in water, sanitation, etc. And so it was a wonderful eye. On the one hand, I got legal experience. I was given the opportunity to go to court. I applied for a protection order for someone who was subject to domestic violence. I also ran a defense in a criminal trial at the time during my in the magistrates' court, of course. And so getting some practical experience in the courts, whilst at the same time doing a lot of other work, such as contractual work, etc. In a sense, legal work surrounding the giving effect to a decent governance across the country. And so it was a wonderful experience to move from a very, let's say, often theoretical, deep engagement with theory to a very concrete practice. And then in 2007, I got the offer just as my book was about to come out to return to academia, and I decided that I wanted to give more thought to some of the issues that I'd seen in practice and return to writing and research.
And you were subsequently, as you say, appointed at the University of Johannesburg. Is that correct? Initially as an associate professor?
So I initially began in an institute set up by Justice Ackerman from the Constitutional Court, which was really recognized the importance of deep academic work for the advancement of the constitutional project in South Africa, the South African Institute for Advanced Constitutional Public Human Rights and International Law, a very long name, which we now just say is SIFAC. And then I became the director in 2009. And the University of Johannesburg, in a sense, there was a merger of SIFAC with the University of Johannesburg. And so I joined the University of Johannesburg then, both as director of SIFAC, which I remain, and as an associate professor initially, and then a few years later, I became a professor.
Well, your PhD was in socioeconomic rights, is that correct?
That is correct.
What was the title of your thesis?
Giving priority to the worst off, the justification and enforcement of socioeconomic rights.
Do you want to take 2 minutes to share with this commission what is important about your thesis in relation to socio-economic rights in South Africa?
Thank you, Chief Justice. The thesis also became a book which is widely available, Poverty and Fundamental Rights, with a few changes. There are two components to the book. The first is a philosophical element of the book, which attempts to look at what is the deeper underpinning of fundamental rights. And one of the important aspects that I try and defend is that socioeconomic rights are no less fundamental than civil and political rights. There's a long overhang in the tradition around rights, which seeks to place rights around freedom rights, should we call them, as central, as the central most important rights. And I try and show why rights relating to the resources that individuals can have access to are no less fundamental than freedom rights. They're absolutely essential, and universally, that is a matter that is applicable. I then go in the second part of the book to look at the approach adopted by the Constitutional Court, which has very much focused on the idea of reasonableness, taking its inspiration from section 26.2 and 27.2. And I argue that the approach of the court actually fails properly to give effect to the underlying justification of rights. So there's the connection between the two parts. And that actually socioeconomic rights, we need to spend more time thinking about what entitlements do they give to South Africans, and where they exist to Colombians and Indians and other people in other parts of the world. What entitlements do they give? And one of the difficulties that we face as a country in South Africa, for instance, is we are resource constrained. So how do we deal with a situation where we have rights and claims that individuals have to ensure to adequate housing, to access to health services, to sufficient food and water? How do we deal with that in a context where we can't meet all those rights immediately? And the book argues for an approach based on, but developing the approach adopted at the international level by the Committee on Economic, Social and Cultural Rights, called the minimum core approach, which requires that the government prioritize a minimum level of access to rights with a duty afterwards to progressively realize those rights over time to achieve a more adequate level of fulfillment of those rights. And so that's a relatively short encapsulation of quite a complex argument, but I hope it gives commissioners a sense of what I sought to argue in the book.
Yes, and you have written numerous articles that have been published on particularly the subject of socioeconomic rights. Is that correct?
Yes, Chief Justice.
Are you able to say about how many articles that you have written have been published in journals and so on?
Chief Justice, I think it's about, I had it in my documents, I think it's about 41 journal articles.
Yes, you don't have to be accurate, just an indication, because it is in the bundle.
In the bundle, and it's about 27 book chapters. I think it's 2 monographs, which is sole authored books, and 5 edited collections. I think that's the correct numbers.
Yes, I was still going to come to that. So how many books have you written chapters in?
I think it's 27, Chief Justice.
27 books.
Yeah.
And were your contributions in all 27 books on socioeconomic rights, or were they on socioeconomic rights and other topics under constitutional law?
A range of other topics, Chief Justice. I haven't only focused on socioeconomic rights. One of my, I would say in general, if I want to capture what my focus has been, I like to always say that the questions I've dealt with is, in relation to rights, is who must do what for whom. We always have to ask those questions when we're dealing with rights, and who is the question of who has the obligations. And one of the issues that I've tried to focus on is to move beyond simply the state, but to actually argue, and I've spent a lot of time looking at the obligations of businesses and corporations specifically in relation to fundamental rights, and that was in fact the subject of my second book. So that was the who question. What is the question of what is the content? What must we do? What do rights give one an entitlement to? What are the claims that they make, that individuals can make, and what are the obligations they impose? And the last part relates to whom. Who are the beneficiaries of the rights? And looking there particularly at vulnerable groups. People with psychosocial disabilities, or in more common parlance, mental illnesses. I've written a paper in relation to that. the LGBTQ community, what rights can be claimed, etc. And we know we've made lots of progress in South Africa in that regard. And then I've also challenged the notion that rights can necessarily only be restricted to the domain of the human, and what rights can be claimed by creatures who are not human or other parts of the environment as well. So that roughly, I hope, gives some kind of sense of the range of topics that I've sought to cover, as well as more theoretical topics about, for instance, the proportionality test of when we limit rights. And one of my chapters, the necessity and proportionality chapter that I've referred to, has been influential in affecting, in fact, the Indian Supreme Court's approach to the limitation of rights and the necessity test.
One is the effect is the position also that one of your writings has influenced the is it the Constitutional Court of Peru?
Yes, Chief Justice. The Constitutional Court, my work on socioeconomic rights, to some extent has been very successful in Latin America with their approaches towards socioeconomic rights and a more individualized approach in some ways. And so the Constitutional Court of Peru has used my work as support for the minimum core approach, as well as the Constitutional Court of Mexico. And in fact, I've also been invited, because of my work, I did a whole course for a Judicial Training Institute in Mexico around socioeconomic rights, which was seen by thousands of judges there.
And to what extent have the courts in South Africa, including the Constitutional Court, also relied on some of your writings?
Chief Justice, I've put in my application, there's, I think, about 7 citations to my writings in different courts. The Constitutional Court has, to some extent, engaged with my writing, on the one hand, to distinguish its approach. So in the Mazibuko case, in a way, it referenced me as the alternative approach to which it's not following. But in another case, for example, the Makana case, it referenced, although it wasn't the core issue around the case, but it referenced my article in relation to dignity and the rights of people with psychosocial disabilities with approval, that we can't always assert that individuals in such circumstances have legal capacity. And most recently, a case note that I co-authored with Professor Ziegler was referred to with approval and seemed to influence perhaps the judgment of the Supreme Court of Appeal in relation to the constitutionality of a provision which denied South African citizenship who acquired other citizenships abroad without the permission of the minister. So I have had several cases where my writings have been influential in the courts.
Now, you have not had any practical experience in the practice of law as an attorney or advocate, other than the fact that you served articles for 2 years. Is that correct?
Yes, I have not. After that, I did not really practice, other than perhaps I was asked as an academic to provide some advice on whether cases, and I've helped in some ways brew some litigation but I haven't acted as an attorney in those litigious matters.
That means, and you also haven't sat as an arbitrator in any disputes, is that correct?
I have not, Chief Justice.
Yes. The acting stint that you have been afforded in the Constitutional Court from February this year is your first acting stint in any court, is that right?
That is correct.
Yes. Now, in the as an academic, it's quite clear that you have written very extensively on the subjects that you have written on. What do you say to anybody who might think that the fact that you didn't practice as an attorney or advocate and didn't sit as an arbitrator, what would you say to somebody who says those factors count against you? What would you say to somebody who says that?
Chief Justice, that is not my experience, of course, but I think the starting point for me is Section 1745 of the Constitution, which says that at all times the Constitutional Court must be made up of at least 4 people who were judges, former judges, and that recognizes the importance of prior judicial experience. But I think it also importantly opens the door for people with a different form of experience to join the Constitutional Court. And so people coming from the advocates profession, the attorneys profession, and judges have invaluable experience to bring to the Constitutional Court. The experience of an academic is a different form of experience. And the question, I suppose, very much for this commission will be, is that experience of the academic something that one regards as important, that can diversify the range of experience and the range of thinking that is open to the Constitutional Court? And I would just like to suggest to you some aspects that academia, that is characteristic of academic thinking. The first is perhaps a type of a breadth of perspective, an exposure to a range of different influences, a range of different systems, different constitutional cultures. And in fact, our Constitution, it seems to me, is an outward-looking Constitution. We're expressly required when interpreting the Bill of Rights to take account of international law and to consider foreign case law. And so it seems to me that those kinds of interactions that someone like myself has had with both global North and global South systems can bring an important perspective to the work of the court. I think we also, as academics, engage all the time with young people, and that challenges an academic. Of course, you start off as a relatively young academic, you become, I suppose, I'm middle-aged, and then you become a more experienced academic, and all the time you're interacting with people with different ways of seeing the world. And that is also challenging and brings a particular realm of experience to the court. And the last point I'd like to make is, I suppose there's a degree of depth of engagement. The academic skill is very much about, as I mentioned when I was describing my book, I didn't just start with legal doctrine. I went all the way back to thinking about what are the underpinnings of fundamental rights? How does socioeconomic rights relate to civil and political rights? And then what implications does that have for legal doctrine? And so it seems to me that that ability to go and have a sense of what those deeper underlying questions, those deeper perhaps philosophical ones, which involve years of research and reflection, can aid the court and bring another form of experience to the court's work. And I think that I would argue that's particularly important for the apex court, where understanding deeper questions of political philosophy, understanding deeper questions of what rights are there for, what is our Constitution there to do, and the deeper, we've also got now general jurisdiction as a constitutional court, what are the deeper underlying principles of the law? These are all important skills that I think can contribute to the work of the court.
Now, during your time as an academic, were the branches of law in which you have published and taught, constitutional law, human rights law, administrative law only, or did you go beyond that in branches such as commercial law, law of contract, delict, jurisprudence? Did you get to write on those other branches of law or teach on those other branches of law as well? And I ask this in the light of the general jurisdiction of the court that you just mentioned.
Absolutely, Chief Justice. My general expertise is constitutional expertise, but importantly, constitutional expertise influences and has an effect on all areas of law. And I think we still have a long way to go of seeing all the other areas of law through the prism of the Constitution. We know Section 39(2) requires, when interpreting legislation or developing the common law, customary law, to have regard to the spirit, purport, and object of the Bill of Rights. And my experience already on the Constitutional Court has shown me that even cases that seem to be purely commercial cases actually raise questions about the spirit, purport, and objects of the Bill of Rights. Now, my experience has actually seen everything through the prism of the Constitution, but it hasn't only been related to areas of public law. And that's because when I started going into issues of business and human rights, I realized very soon that we couldn't just think of this from a matter of human rights perspective. We also have to think, for instance, of company law. How does company law shift in light of the imperative that businesses respect fundamental rights? And so, for example, in my recent book, I have a chapter on how company law needs to change. Doctrines such as the fiduciary duty of directors, heavily really core elements of company law, the business judgment rule, very different elements, the social and ethics committee, all these different areas, the derivative action, all these different elements. How does the Constitution impact on those areas, and how does our engagement with fundamental rights impact on those areas? So I would suggest to you, while I would not claim to be an expert in all areas of law, which I think is impossible for anyone to claim that, I have had an engagement, particularly in areas such as company law, with commercial law, and my commitment would be to try and infuse the values of our Constitution into the full panoply of law in South Africa, so that we really give expression to that idea that we have one legal system that is ultimately grounded in our Constitution and its values.
Thank you. You started acting in the Constitutional Court at the beginning of February. Share with the commissioners what experience or feeling you had coming back to the court where you clerked so many years ago, now coming as an acting justice.
I would say to you, Chief Justice, there was a degree of spine-tingling sensation. It's, I think, a dream of every law clerk to one day be a judge, but I never expected that to happen. I know that the emphasis in our country was against academics being a judge, so I never expected ever for that to happen. So when I entered the beautiful building of the court, which so gives expression to the values of the Constitution, it was really an extraordinary experience, and a humbling one, and a great, in a way, fulfillment of a dream to me, to come there and then to be embraced by the wonderful collegiality of the colleagues at the Constitutional Court. Of course, there is a learning curve into the systems of the court, and to be shown and to be guided in that way, it has been an extraordinary experience. And also one, I would suggest, that also has benefits. If my candidacy goes no further, I will have a deeper experience on understanding of what it is like to be a judge. And I think that is also a great benefit of having academics on the court, that there is a deeper sense of the constraints of judging, as well as the pressures and what it is to be a judge. And so I really forever will value this extraordinary opportunity.
And then, of course, what about the first day you walked into the courtroom with all the other justices for the first time, and not sitting where the law clerks sit, now sitting as one of the justices?
Chief Justice, I had to pinch myself a little bit. I was quite nervous, and I think, as people will know, I also I always prepare very well, but for that first hearing, one had to be beyond super prepared, because I was, I was like, well, this is the first one, and so it was an extraordinary moment to wear the robes and to assume this high office, this sense that the people of South Africa have entrusted us with the guardianship of the Constitution, which brings all the people of our country together with a vision of a different type of future, a recognition of an extraordinarily painful past and filled with injustice, but a movement towards a more democratic, egalitarian, free future that improves the lives of every single South African. And that is the sense of responsibility that I felt as I entered that courtroom.
And share with the commissioners the experience you have had of acting and interacting with the justices of the court over the past 2 months, February and March, how you found it and how you found interacting with the justices and how you found the work to be.
Thank you, Chief Justice. It was, as I've already mentioned, an extreme generosity. I really felt and experienced the African value of Ubuntu in action, of people caring and trying to make me a part of the court. I also, as might come up, I relatively early on disagreed with some colleagues. It's a matter of public record now on the Rivonia Circle case. And what was fascinating to me and extraordinary was the approach to disagreement. It wasn't that we were antagonists. We had differences of view. And in fact, my colleagues who disagreed most strongly with me tried to help improve the reasons I gave and vice versa. And that seemed to me an extraordinary culture where we embrace and recognize we may not all have the same point of view, but we try and make each other's point of view and expression of opinions the best that it can be. And that is a tremendous culture that exists at the Constitutional Court. As you mentioned, I think the case, I'm a very busy academic involved in many, many different facets, but I found the workload at the Constitutional Court was absolutely massive increase. There is a huge number of new applications which we continue to have to consider, the degree of preparation for every single hearing, the consideration of the issues that come before the court involves a really deep engagement. And so I have the most tremendous respect for all the judges that are working under this continued pressure of a massive caseload and trying to advance in best way they can justice for our country.
You were not able to favor this commission with a copy of any judgment that you have written during your acting stint. Is that correct?
Yes, Chief Justice, it is a degree unfortunate. I only started acting in February, so it is only 2 months. I did work very hard on trying to have a judgment ready for this commission. But the Constitutional Court is a complicated court in terms of just rushing out judgments. It is the authoritative word on matters that come before the court. And as a result, there's a degree of care and caution that needs to go into the preparation of judgments. And so even if a matter is unanimous, there is a range of matters. One has to take into account the range of perspectives that come into a decision. And if it's not unanimous, one needs to have an opportunity for different decisions to be prepared. And so whilst I cannot comment on exactly the particular case that happened, there was a real effort on my part to achieve that. But the need for care around only issuing a judgment once everyone is satisfied with that meant it was not possible to have one ready for the commission to inspect.
Well, I can confirm that you really worked hard to try and have it ready before your interviews, but the dynamics were such that ultimately it shouldn't be rushed too much. It's not ideal, but you did all you could. Now, you are going to continue acting in the second term, is that right, in May?
Yes, Chief Justice. I am still currently a sitting judge of the court for April and May.
Yes, yes. Now, let's talk about other matters relating to the adjudication of cases. Some of the questions I might put to you, it might be questions that maybe somebody who has had the benefit of practical practice might remember easily, I'm not sure, but I think that even an academic, they would be aware of the principles and so on. When you are dealing with a matter where the Constitutional Court, you are sitting in the Constitutional Court, you have concluded that a certain piece of legislation or a provision in legislation is constitutionally invalid, and that you are going to have to make that order. What other issues should come immediately to your mind that are related to what else you might have to look at when you make that order?
Thanks, Chief Justice. I mean, this implicates Section 1721 of the Constitution. And of course, the first thing, if a matter is required to be declared unconstitutional, then if it is found to be unconstitutional, it must be declared to be unconstitutional to the extent of its inconsistency. So that's the first question one has to look at. One wouldn't declare a whole statute invalid if only one part of the statute is not constitutional. The second part requires one to make any order that is just and equitable. That requires a wide-ranging discretion, and some parts of that in relation to the declaration, there's a question, for instance, of does one make the order retrospective or only prospective? Does one suspend the invalidity of the order? You could create, for instance, a major gap in the legislative system if you simply declared a matter unconstitutional and leave a hole which actually can't. It's not acceptable to do so, and causes all kinds of harm to the administration of justice. So you may want to suspend sometimes the invalidity and give Parliament an opportunity to correct for that, and the court has done that on many different occasions in relation to suspension of declarations of invalidity. There are, of course, a range of different issues that relate to the order itself. You want to do justice to the parties. The Constitutional Court is also concerned not only with the parties, but the wider community as well. It needs to consider those kinds of questions. It may be that you declare something invalid, but people operated on the assumption that it was valid, and therefore it would be completely unfair, for instance, not to provide some compensation in certain circumstances for where people had operated on that basis. So those are perhaps some of the factors that would come in to thinking about remedial relief. And also perhaps, like in areas which I'm expert on, socioeconomic rights, we would sometimes think about how practically to give effect to an order might require a continued backwards and forwards process between the court and the branch of government concerned, such as structural interdicts, etc. So I hope that to some extent answers your question.
Yes. And when do you use reading in and when do you use reading down?
Reading down will be when we can interpret the Constitution. It relates to 39.2, when we can interpret the Constitution, the provision in question, of a statute in a way that is in conformity with the Constitution itself. And the court has laid out a range of principles. In fact, one of the cases was one I worked on when I was a law clerk with Justice Lange, the Hyundai case, where there was a question of how far can you stretch the language of a provision to make it consistent with the Constitution. That will be a judgment call that the court has to make of whether it can read it in conformity with the Constitution. Reading in is a different remedy. It involves when one has in fact declared a matter unconstitutional. But then generally the court, again, another factor we need to bear in mind as well when issuing remedies is the separation of powers. And we don't want to rewrite legislation fully as a court. But the court has in some cases, for instance, where there's an exclusion of a group. For instance, in many of the LGBTQ cases, there was a provision, for instance, that related to pensions for a spouse, which was understood at the time only to refer to heterosexual couples, and the court read in or permanent same-sex life partner to include a group which had been impermissibly excluded. And so reading in often is very useful to do that, where it's not really necessary to burden the legislature to make a major modification to the legislation, but to, in sense, include a group that was previously excluded.
Thank you very, very much. You know, Section 177(1) of the Constitution lays down grounds on which a judge may be removed. Two of those grounds are gross incompetence and gross misconduct, which suggests that mere incompetence and just mere misconduct are not enough to remove a judge, which might sound extraordinary. But the question is, what is the constitutional significance of that choice in the Constitution? Namely, a judge can't be removed just for mere incompetence. It's got to be gross incompetence, and it can't be removed just because of mere misconduct. It must be gross misconduct.
Chief Justice, I think the underlying, again, I think that my approach to the law is very much purposive. What's the purpose underlying the provision? And I think the key goal here is that we cannot have judges removed too easily from their positions. If one's going to guarantee judicial independence, one needs to ensure that judges can remain in their positions, can make decisions without the fear of being removed. And I think the worry is that if one simply talked about incompetence, someone might say, well, that decision was not competent because they may have disagreed with the outcome, or perhaps may have thought that the judge didn't properly evaluate matters. And if you can remove judges too easily, that would allow for interference with the judiciary, and judges would be really afraid to make the decisions that they should make, and the fierce independence that they should demonstrate. And so I think the constitutional drafters put those qualifiers, gross and gross misconduct, to distinguish and to also to recognize that on occasion that people may behave badly, right? We're human beings, we are flawed, but it's a question of whether does the misconduct go to the heart of your function as a judge, and we have to ask those kinds of questions, right? It's not just simple a flaw in your that you made a mistake. And you didn't behave well, but does it go to a fundamental flaw in your capacity to be a judge? And so I would suggest that it's deliberately difficult to remove judges from their office, particularly to guarantee judicial independence.
Thank you very much. And what can you tell the Commission about the principle of subsidiarity?
The principle of subsidiarity, I'm going to give a relatively simplified approach to it, but the Constitution requires, for instance, that certain legislation is passed to give effect to rights, such as the right to access to information and the right to administrative justice in Section 33 of the Constitution. And when you're challenging a government decision, for instance, relating to administrative action, you don't come first to the Constitution. You start off, you need to utilize the legislation first, and then you can only challenge, you only engage with the Constitution if the legislation is itself not constitutional, is not constitutional. So the principle ultimately protects and respects the domain of the legislature. The legislature is required to make the laws, and we don't go to constitutional issues unless we have to.
If you look at the judgment of the Constitutional Court in Subramani, as well as the judgment of the Constitutional Court in the Treatment Action Campaign, what are the features that you find in the Treatment Action Campaign judgment, which you don't find in the Subramani judgment, that you think may have made it easier for the Constitutional Court to reach the judgment, the decision that it reached in the TAC matter?
Thanks, Chief Justice. Well, the Subramani matter, for
all of them, just some of them.
Just to summarize for those who are also not familiar with it, dealt with access to kidney dialysis for someone, Mr. Subramani, who was terminally ill. And the Constitutional Court was faced, in a sense, with its first major socioeconomic rights case, with a very difficult judgment, because access to kidney dialysis involves, it's an expensive treatment, it involves a long time on a machine, and so the Constitutional Court was faced square on with the lack of resources in the healthcare system in South Africa. And it had to make a judgment about, and it was a deeply, I imagine for the judges at the time, a deeply traumatic judgment, because Mr. Subramani, if he did not receive dialysis, would in fact die. And that is what happened, right? The Constitutional Court said, we have to construe rights in relation to the resources that are available in the society, and we cannot at the moment, the government has made a good faith decision to restrict dialysis to only certain categories of people, for example, who could be cured. We're not prepared to second guess the government in that regard, given it has to ration scarce resources, and as a result, we cannot give he doesn't fall into those categories, and Mr. Subramani cannot have the treatment that he needs, and he in fact passed on a few days after the judgment. That is in fact a court facing decisions of life and death. And before I come to Treatment Action Campaign, let me say, I think the main worry, in my view, with the court's judgment in Subramani was its willingness to say that rights are defined by their relationship to resources. I don't think rights should be defined by their relationship to resources. I think people in South Africa do have a right to kidney dialysis. We may not be able to realize it fully at the moment given resource constraints, but the rights place a pressure continually on the government to improve access to those goods such as kidney dialysis. And so the court shouldn't have defined away the right. It should have recognized that there was, in fact, a justifiable limitation that could have been placed on that right, rather than saying that there was no right in the first place. So I worry about that approach to rights in Subramani. Treatment Action Campaign case dealt with the context of the high rates of HIV/AIDS in South Africa in the early 2000s and the transmission from mother to child of HIV, usually taking place at birth. And it dealt with a medication called nevirapine, which was extremely successful in reducing the incidence of transmission of HIV between mother and child at birth. Now, an important facet in this regard was that the manufacturer had made the drug available to the government for free for, I think it was 5 years. And yet the government at the time said, we're not going to make this drug, which can help literally save those children's lives, available throughout the system the healthcare system in South Africa. We're still testing it. We're making it available only at 2 sites per province. And if one is aware of the size of our country, the fact that many people can't afford transport, it was not possible for people to get to those centers. And so as a result, people would die simply because the government was not making available a drug which was available for free. And so in the treatment action case was, as a result, a lot easier in many ways for the Constitutional Court. It didn't have to face the resource problem because this was a drug that was available for free in the system. And there wasn't a clear explanation by the government at the time why it was actually refusing to expand access to this drug across the country. And so the Constitutional Court found that in that case it had been unreasonable to refuse to expand access to nevirapine across the country. And that judgment, I think there's a study done by Harvard, saved hundreds of thousands of lives in this country because the government, to its credit, followed what the Constitutional Court had said, made the drug available, and it also changed the general approach towards antiretroviral drugs in South Africa, to the extent where I think South Africa now has one of the highest rates of access to antiretroviral drugs in the world, which meant that HIV became a treatable disease and not a death sentence. And as a result, I think that case forever, I use it when I teach overseas as well, to show the power of socioeconomic rights to make an intervention that can literally save hundreds of thousands of lives.
My last question, sitting in the Constitutional Court deciding, dealing with a constitutional matter, when would you use the remedy of actual severance and when would you use the remedy of notional severance?
Chief Justice, I think the remedy of severance is like the opposite remedy of reading in. Reading in is about correcting for the exclusion of a group. If there's an ability, for instance, without distorting the legislative scheme, to excise the unconstitutional element of legislation, you would excise that part of the legislation. And again, you need not send it back to the legislature to address it. But it mustn't fundamentally alter the constitutional scheme as a whole. It's in a sense, it's like if you have a discriminatory provision, you cut out the discriminatory element in that provision. Notional severance it doesn't involve actual cutting out. It involves reading a provision as if it's cut out the unconstitutional element. So it's not the actual deletion of words, but it's saying that this is unconstitutional, and in future, we are going to read the provision as follows, in the following way. I think the case that was done, for instance, was, I think the name's escaping me right now, but for example, where there was a reverse onus provision, the court and an evidentiary burden in relation to property that was which someone was found in possession of stolen property, and my sense is that the court said, well, this is not going to be read as a reverse onus, but it must be read as placing an evidentiary burden to explain the possession of the property. So it's not changing the words, it is actually reading it in a way that's constitutional going forward.
Thank you very much, Minister.
Thank you very much, CJ, and good afternoon, Prof. Bilchitz.
Good afternoon, Minister.
You have already indicated that your judgments are cited with, your books or writings are cited with approval, particularly on socioeconomic rights in Peru, Mexico, mostly Latin America. I guess it will be that there are certain characteristics we may have similar to them in terms of an unequal society. How do you think your approach on the enforceability of socioeconomic rights could be impacted by this co-approach that you're advocating for versus the reasonableness approach?
Thank you very much, Minister. You are absolutely right, firstly, that there are similarities between South Africa and certain other countries in the global south. And my interest has actually been largely, if you look at my work, has been on global south constitutionalism and actually looking at the comparisons that we can draw between our country and some of the leading, generally democratic countries around the world, like Colombia and India. I've just released a book that just came out this year, actually the first deep comparison between South Africa and Colombia, which also is a country struggling with poverty, struggling with a legacy of conflict, and also with deep socioeconomic inequalities. What is the difference that the approach that I propose makes? Well, Minister, my goal was to try and find a way in which we give a sense in which the socioeconomic rights in our Constitution are not just empty promises. They're not just promises that people will get access to these goods in 40 years, in 50 years. They are actual rights. They are claims that people can make. And how do we give effect to the fact that they are claims? How do we give teeth to those rights? And what I tried to do, I said in a resource-poor situation, which is faced by many, many countries, as I say, in the global south, with a large need and limited resources. How are we to deal with the fact that these are rights? And what I suggest is that we need to define as South Africans, and part of this is the role of the court, and part of it is the role of the legislature and the executive. We need to define a minimum level of access to these goods, of housing, of food, of healthcare, of education, right, that everyone in this country can have, and below which we do not accept is acceptable within the South African political community. My reading of the placement of socioeconomic rights in our Constitution is that we placed certain things outside the boundaries of politics. We said in 1996 that whether you have access to housing, food, water, etc., is something that we are going to guarantee as a matter of right. But it's easier said than done, right? It's not simple to do in a country which is resource poor with so many demands on the fiscus and such complicated socioeconomic conditions globally. And so the goal was to define a minimum, right? In my book, I define the minimum relatively at a very low level, but one of the suggestions, and I think correctly, is to actually say that we as South Africans can come together and define for us what constitutes the minimum below which we will not accept people go. And the Constitutional Court then enforces that minimum and then requires government over time to improve that minimum to the point where we recognize that everyone has access to fully adequate housing. So there's a distinction between what we might call minimally adequate and sufficiently adequate. And my goal was to say, we cannot tolerate, right? When we go out on the streets in Johannesburg today, on this very rainy and cold day, there are people outside who are not able to have a roof over their head, who struggle with access to food on a daily basis. We have malnutrition. Only 10 minutes down the road from where we are now. And we need to decide, and the district, and my reading is the resources in our country and the distribution of resources in our country can guarantee a minimum level that we will not accept anyone in our community going below to live a life of dignity and autonomy. And that is a challenge, I think, not just for the Constitutional Court. It's a challenge both for the legislature, for the executive, but it's also a challenge for the judiciary not to get used to too procedural ideas. In a sense, I've criticized the judiciary for taking the idea of reasonableness, and it's very vague. If I go to someone who lacks food and say to them, you have a right to reasonable government action, that doesn't sound like a right. I want to be able to say to someone who is poor, you have a right to sufficient food, and the Constitutional Court will guarantee you at least a minimum level of access to certain resources in our country. I hope that broadly explains it.
Yeah, no, I think you have clarified me. You have mentioned the workload at the court, and I suspect it also comes from experience as a clerk and also now. I just want to get your view. There has been a suggestion here by Justice Matopo when he was being interviewed that he thinks that we need to collapse the Supreme Court of Appeal and the Concord, make it one court. Do you think that could improve the issues of in terms of the number of judges, the workload, and also access to justice? His approach was that maybe we could look at it working in chambers. I think is an approach of the Supreme Court of Appeal.
Minister, my view is that we should not collapse the Supreme Court of Appeal and the Constitutional Court. I think that both courts perform a very, very important function. And I think it's really critical that one has access to appeals on the basis from high courts, for instance, on the basis of fact, for instance, in relation to criminal law and civil law, and that there's a higher body which is made up of a number of judges which considers those issues, as well as the legal principles that are applicable. But I do think it is actually a really important aspect of our country that we have a court which is dedicated to thinking about how to, in a sense, fundamentally transform our law in relation to the imperatives of the South African Constitution. And as I've said, I think that applies not just to the constitutional jurisdiction of the Constitutional Court, but also the general jurisdiction. And the court, whilst, as you've said, the workload is very high, the court still actually has a relatively small number of cases compared to the general appellate jurisdiction required of the Supreme Court of Appeal. I don't have the exact stats with me, but you will be more familiar with that. But the court, that does provide an opportunity, despite the intense pressure of the workload, of giving deeper consideration to the most fundamental principles in our political community and how to give effect to rights. And so I think, so I do think that actually there's room for both sets of courts. I think we can improve, as you've said, in terms of the workload. There have been certain proposals made by the Chief Justice as to how to address particularly the big burden that arises from applications on leave to appeal, where we need 8 judges to signify their agreement as to whether to accept or dismiss a case in relation to leave to appeal. And it seems to me that there are ways institutionally to address that through, for example, allowing smaller panels to make those decisions, and also enhancing perhaps the experience, or having some experienced lawyers who assist in the preparation of those of memorandums, although the final decision must always be made by Constitutional Court judges.
Yeah, thank you very much, CJ.
Thank you, Minister. Justice Mulemela.
Thank you very much, Chief Justice. Maybe to take up on the last point, where your suggestion in relation, first of all, I didn't even greet you. Good afternoon.
Good afternoon, Justice.
How are you?
Yeah, President, sorry, Molemela, really nice to engage with you.
Yes, thank you very much. So it's just a follow-up to the Minister's question in relation to easing the workload of the Constitutional Court. Because, I mean, it's something in the public domain that its workload, and of course that applies to other courts as well, has increased tremendously. And it would seem that that is having an impact in the delivery or expeditious handing down of judgments. And my question is, I'm not now talking about collapsing the Constitutional Court and the Supreme Court of Appeal, but just on that point that you made, that perhaps other people could be involved to assist in relation to the preparation of memoranda and so forth, would increasing the number of judges in that court not assist in relation to that aspect.
President Molemela, thank you for that.
Maybe let me interrupt myself just to say, I know that it would require a constitutional amendment. So many solutions actually will require a constitutional
amendment.
Yes.
Yes.
But would that alleviate the problem?
I think we need to debate a lot of different possible institutional solutions to some of the issues that we're facing as a judiciary in South Africa. I think we also have to remember that, you know, a lot of people also still face problems in accessing the courts. And so if we were to make access to the courts easier, we would face even more cases. And I support making access to the courts easier. And so we need to grapple very strongly with what are the possible institutional solutions to deal with this. One, as you've suggested, I mean, I think one possibility would be to increase the number of judges. I think we would need to rethink the rule of en banc decisions then. I don't see how it's already with 11 judges. As we've said, one of the difficulties and reasons for delay is to bring everyone on board and to ensure everyone's opinions are taken concern of. And so I think one would need to, if we did increase the number of judges, and of course there are constitutional courts, like for example in Germany, they sit in 2 panels, 8-8, and we could, for instance, have a way of approaching matters where I think the strongest case for a large number of judges sitting together is where an act of parliament is declared unconstitutional, because that is the strongest exercise of judicial power that we have. I wonder in terms of, for example, whether the general jurisdiction of the court could also be dealt with through sitting in panels. That may be an option even without increasing the number of judges. But I think ultimately in South Africa, if we are going to make access to justice accessible to everyone, we are going to have an increasing demand on the courts. The last report I saw from the judiciary, I think which was 2022, said that there were 253, I think, high court justices across the country. That is a very small number for a large country. And although I don't want to give the Minister of Justice heart failure, I think that we do need to grapple with the need for more judges across our country. Just to give you a sense from my comparative experience, in Colombia, they have an action called the tutela action, which allows people whose rights are violated to approach a court and to receive a decision in, it dispenses with a lot of formalities, and to receive a decision within about 10 days. They have thousands of judges across the country, and the workload of the Constitutional Court, when I went there, I just saw there's almost like a warehouse of files. That itself raises lots of problems, and I'm not sure we should go that model. I think South Africa, we've adopted a different approach by trying to allow the Public Protector and South African Human Rights Commission to address many of the ordinary complaints people have. But I think your proposal is one that I think we need to think about very seriously as we recognize that we plan for the future. The demand in the judiciary is not going to get lower. It's probably going to get higher. Of course, we can hope that, in many ways, our human rights will be more realized in South Africa, but there are many challenges facing us. And as I say, I think that would be one proposal we need to think about.
Thank you very much. My second and last question, and maybe I should give a preamble to say, I embrace the diversity that comes with Section 174.5 that you have referred to. So please, I just want to put your mind at rest that the question that I'm going to ask you is not because I think that an academic should not be appointed in that court. I think it is important for purposes of diversity. However, it is a fact that there are ways in which the competence of judges can be assessed very, very easily. There are a number of factors that can be taken into account, but the ability to work under pressure, for example, is one of the good indicators of a good judge. And the ability to also produce work of good quality under pressure. So in relation to a judge, one would look at their judgments and say, this judge has a track record of writing very good judgments, well-reasoned, the analysis is perfect, and importantly, they are produced reasonably quickly. In your case, you have not yet authored a judgment, and I'm not criticizing you for that. I don't expect an academic to produce a judgment. I mean, where would they have written it? The point that I'm just making is, while for me, it was easy to assess the quality of your articles, I've read them, and I found them to be of good quality. There's one area in which I want you to assist me in relation to your ability to work under pressure and to produce results relatively quickly. Because, you know, the situation for judges is like we are standing at the end of a conveyor belt. We are working all the time, but at the same time, we have to wait at the end of the conveyor belt to receive new work. So it's an ongoing pressurized environment. And I want you to persuade me that you can work under those circumstances. So I would like you to make examples, because ordinarily I'm not able to assess. And in fact, the GCB as well in their report quite correctly state that it is not easy to apply the ordinary criteria in relation to you. And so I know that we would assess the quality of your judgment by looking at how impactful it has been. And I have no doubt that your articles have been impactful. There you are. You say they have been relied upon in Peru and in Mexico and in several other countries. I have no issue with them. But can you give examples of how you were able to work under pressure, meet deadlines, and still be able to produce work of good quality? I know that as an academic, to become a full professor, which you are, you have to author articles, and you have mentioned, you have alluded to that. You also have to supervise students and so forth and so forth. But I want you to please give me examples of how we can fairly say Professor Bilchitz will be able to work hard and produce very quick results in terms of judgments at the Constitutional Court. Thank you.
President Molamela, I don't want to suggest that the academic experience is able to be entirely comparable in any way with the pressures of judging. At the same time, the academic experience also isn't like, I wish it were a case that we just spent all our days thinking and writing. We have various pressures in terms of, we teach courses, as you've said, we have administrative responsibilities. We have, I've been very involved in actually trying to stimulate academic engagements. I ran a massive conference, for instance, with over 650 registered delegates from all around the world in South Africa. And I balance those elements with being productive. So I think what I can say to your response is that I think my productivity as an academic, in some ways, my ability to produce multiple articles, it's not a sense in which I had for instance, around the book, I had a sabbatical, and that's not comparable. But when you have ordinary academic work and you are busy organizing massive conferences and you still bring out a book, you still bring out a second book now that's just come out with an edited collection and writing, I think it suggests that I'm able to manage and juggle the demands of a range of demands that are in the profession of particular pressures with the need to be productive and to be able to achieve a decent level of productivity of also what, as you've said, is quality work. So I think the key thing is that one needs to work under pressure to produce quality work. I think one of the benefits of academia is that we do at times have the opportunity to step back. And I think what I think an academic candidate may bring is the ability from that stepping back to draw on that experience to be able to more quickly be able to address some of the issues in the judgments. And so seeing that, one doesn't have to go and get all that depth as you're busy learning about the matter, but you've already got the depth of experience, you can bring it relatively quickly into the judgments that you write. As you've said, I have had pressures around producing reports. So there are aspects where we produced a massive report around the performance of the South African Constitution for international idea, and we had set deadlines around that. And there are other examples like that of having produced reports, of having to work with civil society. For instance, I was asked to appear before the United Nations to make input around a business and human rights treaty. I, together with my institute and other civil society organizations, organized a meeting of civil society, and we had to, within a couple of weeks, produce documents and inputs into that process. So these are some examples I can give you of what I've done, but I can't give you an exact parallel of the pressures that you may face as a judge. But I hope it may satisfy you that I'm capable of working under that pressure.
Yes, sorry, Chief Justice, just a last comment, once again, to put your mind at rest. Just to say that we have had academics who became judges at the Supreme Court of Appeal and the Constitutional Court, and who fared very, very well. They were very good judges. Thank you.
Thank you, Justice Miller. I've been informed that the latest we can take our lunch is 2 in terms of the hotel. Otherwise, after that, I think I'm told there may be safety issues about food. So, so that being the case, I'm thinking that the next one, I will let them be the last one before we take the lunch break, the next commissioner to ask questions, and then we can continue after that. The next one will be Commissioner Moimang.
Thank you, Chief Justice. Greetings to you, Prof.
Greetings, Commissioner.
Just a follow-up on the minimum versus reasonableness approach. Don't you think that the approach by the court on Masibuko, on Grootboom, and on treatment action campaign was mainly informed by the fact that the court appreciated the separation of powers and the fact that the executive is much more in a better place to provide information in terms of given the resource constraints, is better placed to determine the budget allocation as opposed to relegating that to an arm of government that necessarily is not in that position, because budget allocation balancing the priority needs, the best arm of government to do that is the executive, and therefore, hence the court was a bit cautious in terms of descending into the arena of terrain that belongs to the executive arm of government. Thank you.
Thank you very much, Commissioner. You raised one of the main questions, and that was raised about the justiciability of social rights. For many years, academics said, well, social rights can't really be justiciable because we don't want the judiciary to be making decisions about issues which have huge budgetary implications. And there are 3 main challenges, right? The one is a legitimacy challenge. Is the court the right space in which to make these choices? The competency, does the court have the competency? And that these rights were actually to some extent indeterminate, that they don't have a clear content. And over the years, there's been a number of different ways of responding to that. The first important response, I think, to you is that is what the court does in relation to socioeconomic rights fundamentally different to what it does in relation to civil and political rights. Civil and political rights, the court gives expression to, it gives content to a right. So let's take the right to vote, which is all on our minds at the moment, right? And the court identifies a standard, right? And says we need to ensure the secrecy of the ballot, right? The court role is to interpret the right. Now, the legislature and executive need to go and give effect to what does it mean to give effect to the secrecy of the ballot, and what is required for that. Maybe a special computerized system, ink on our thumbs, all kinds of different ways of doing that, right? But the role of the court there is to define the constitutional standard against which we test whether the executive or legislative action meets that constitutional standard, right? And some forms of approaching to voting will meet that standard and some forms won't. My argument has been that socioeconomic rights doesn't impose a task on the court fundamentally different to the task that it has in relation to civil and political rights. The South African people, when passing the Constitution in 1996, included social rights. And they said specifically that judges would be able to decide ultimately whether action of the government or the legislature meets the constitutional standard. And so my argument is it is entirely appropriate for judges within the Constitutional Court to outline the standards that these rights require of the government. Not to tell them exactly what to do, but to tell them what is that minimum standard that's required? Does it involve, for instance, protection from the elements, the rain that we now have? And does the approach of the housing ministry, does it actually meet that standard? Well, then the court can evaluate that. But if the court simply says to the government, be reasonable, right? Whatever you do must be reasonable, that is a very vague standard. It doesn't really tell us what people can claim, and it fails to give proper expression to the interpretation of rights. So I hope I've, in a brief way, I haven't dealt with all those objections I mentioned. We can have a discussion about that if you want to. But I think part of it is I'm trying to stick with the role of the court in interpreting rights. And I believe that there's an opportunity, what we see in academic life, for a kind of dialogue between the courts and other branches of government in how best to give effect to these rights, which are so really vital in our political community.
Thank you. The second one relates to, I see that you also express yourself on the positive corporate fundamental rights, the legal obligation of business. Now the question that I want to pose in relation to the latest amendment to the Companies Amendment Bill and the Second Amendment Bill, which is a direct result of the work of the Zondo Commission and the recommendation that the Companies Amendment Bill must be amended to remove the time bar in terms of holding the directors of companies accountable, even when they have left the company where malfeasance could have happened. But the second aspect related to that also, to the main bill, is the extent to which shareholders will hold the board of directors accountable in terms of the remuneration policy, but also more than that, the fact that the shareholders will be able to determine what has to be attached to CPIC in terms of the annual financial statement. They would want a report in terms of the extent to which the shareholders are able to hold the board of directors accountable in terms of dealing with the inequality and disparities between the directors, the shareholders, and ordinary employees of company, to deal with the gap in terms of inequality. What is your view in relation to that against your position in relation to the legal obligations of a business, and also positive obligations that you are imposing in terms of ethics to the companies? Thank you.
Commissioner, I think there may be a degree to which I can't answer questions as a sitting judge or as someone who may be appointed to the Constitutional Court about specific legislative provisions, because that could implicate, because they could come before the court itself. What I can say, I can perhaps answer your question in broad terms about corporate responsibility and the need to think about what I've tried to suggest is that we should not see a corporation as purely a body that is designed to maximize the profit of shareholders. That a corporation is a body that is actually created by statute, and for that reason, it is meant to bring social benefits to our society. And there are certain traditional approaches to why it can bring social benefits, because it provides separate legal personality, etc. But those various elements of a corporation, separate legal personality, particularly in limited liability, create various threats and challenges for, on the one hand, the relationship between shareholders and directors, and the responsibility of the company more generally, financially, right? And a lot of company law is trying to address the potential irresponsibility that's created by this principle of separate legal personality, and trying to address the separation of ownership and control and these kinds of questions. And the key approach of the company being also to advance social goods as well. Our Company Act does say that, in fact, and I think there's a pretty clear reading of our Constitution, which is why I'm not straying too much into controversial territory here, where companies are in fact bound by the Bill of Rights, and bound by obligations in terms of the Bill of Rights. So to the extent that, as I said, I'm not sure I can express myself on the particular amendments and the particular purposes that they are being given, but what I think we need to recognize is that there has been a shift in South Africa with the passing of our Constitution, from a simple recognition that a corporation is just part of the private sphere and must go about its role no matter the effects on others in the community, to a recognition that it has wider social responsibilities, wider responsibilities for rights, and has to act in a way that is accountable, both to those who are parts of the company as well as those who are outside of the company as well.
Thank you, Prof. Thank you, Chief Justice.
Thank you very much. We are at 7 minutes to 2. I think we should take the lunch break now. Professor Bilchitz will take the lunch break now. Should we take 30 or 40 minutes? 40 minutes? Okay. We will then take 40 minutes. That will take us to 25 to 3. So let's return at 25 to 3. You will come back at that time as well, Professor Bilchitz.
Thank you, Chief Justice.
Thank you very much. Professor Bilchitz, we are going to continue with the interview, but I'm going to ask you to try your best, please, to be succinct in your responses. I did give you some leeway in the morning, so try and not be long.
Thanks, Chief Justice. I will try.
Thank you. The next commissioner is Commissioner Steinberg.
Good afternoon.
Good afternoon, Commissioner Steinberg.
I want to follow up actually on the last question that was raised, and really the question of the separation of powers. I don't accept that setting a standard for one of the ordinary political or civil rights is quite the same as setting a standard for a socioeconomic right. Both because there are necessarily bigger budgetary implications, but also, even more importantly, because there are fundamental policy choices for any government to make. If a government decides that the right to housing is best achieved through facilitating loans or subsidies, or then that is government policy within the realm of what democracies do. And coming out of that, I want to ask you specifically, when you say you could set a standard, say, for housing or health, is a court going to tell a government that there must be 4 walls, a roof, a this or that? Is a court going to say access to primary health care, and that includes the following? In the clinic, there must be X number of clinics per, no one should have to go further than X number of kilometers. What does it mean to set a standard in an area that is highly specialized, highly policy-driven, and enormous budgetary implications? So that's question one, really, is practically, what does it look like? If you could write what the minimum content for housing and health are, what would they be? And then following that, if government says we don't have budget, or we don't agree that should be the minimum standard, aren't you setting up the courts for a legitimacy crisis? That you impose a standard that government is unwilling and unable to meet. You made a fairly offhand comment that we have sufficient resources for these things. How do you know that? How do you know we have sufficient resources for a particular level of service? How does a court ever know that? And what then happens when government comes to the court and says, well, that's your minimum standard, but we can't meet it?
Thank you very much, Commissioner Steinberg. And I know also I'm aware that we have disagreed in academics journals about these questions. So it's nice to engage with you about these in this forum. Let me first say that I don't accept that socioeconomic questions in South Africa are simply a matter of policy. In my view, they are in the Constitution because they are rights. And rights mean something and require something. And they require something of the judiciary, not alone of the executive and the legislature. And so the question is perhaps, and you wanted to ask me, what would it look like to provide a standard? So let us take the approach of the Constitutional Court in the Mazibuko case, where the standard, where a community not far from here challenged the minimum basic water allowance as not being
Sorry,
sufficient.
I'm going to interrupt you because I think water's too easy. I'd like you to talk about healthcare and housing, one of those two.
Okay, well, yeah. I mean, I think often, and way we work academically is also to be able to understand from the simple principle to the more complex, and so that's why I'm starting with water. And I just want to I want to explain what I mean in relation to that. Is that the Constitutional Court simply said, well, we have to assess the reasonableness of government's policy in relation to water. But my question is, how do you assess reasonableness without actually considering the needs people have in relation to water? And so what the High Court and the SCA did, which I think in fact were better decisions, is they said, well, in order to work out whether the government has been reasonable, we need to work out whether people have enough water to drink. Do they have enough water to clean? Do they have enough water to wash? Do they have enough water for various purposes that underlie the human interest in water? And then once we understand that, that's the general standard that the court sets, which must be met. And it may be different in different parts of the country in terms of what's required and etc. And that will be up to the government to decide. But the general standard is, in relation to water, sufficient water will be sufficient water that meets the human needs for water in relation to, and one can specify that a little bit more detail. In relation, you asked me about housing. So how would one specify a minimum in relation to housing? Well, I think one of the elements of housing that people need, as I mentioned, is the fundamental aspect is protection from the elements, right? So that they're not outside in a torrential rainstorm, or as is happening in the Cape at the moment, a hurricane. And then we need to also have a look. We actually have some suggestions from the Constitutional Court in the Grootboom case, right? And what disappointed me in Grootboom is, to some extent, the court set a minimum standard, but it refused to say it was setting a minimum standard. And it actually said, well, what constitutes desperate need? What constitutes that minimum that people need when they're in crisis situations? And those minimums included protection from the elements with access to basic services in sanitary conditions. There we have an ability to set a standard, and then we can ask ourselves, does any government program meet the standard that the rights require in that area? Now, we could have a kind of long debate about that. I think one of the ways we could also have a participative process in some ways in doing that. So one thing that's happened in relation to education is that actually a number of NGOs have gone to court and asked for minimum standards for schools. And what's happened is the court hasn't set the minimum standard, but it's required the government to set that minimum standard. I would also be comfortable with that approach because it allows for input from other branches of government into what constitutes that minimum standard, but it also sets a minimum standard so that we know when people around our country come and ask us, do we have the right to basic education? We know what constitutes at least the minimum conditions for that basic education. So I hope I've touched on that a little bit. And you asked me then the question, well, what about the budget? What happens if we absolutely don't have the resources, or how do we know that we have the resources or that we don't have the resources? Well, in many cases, it isn't that difficult to tell. And in some cases, the Constitutional Court has simply said, for instance, that in relation to the extension, for example, of grants to permanent residents, the court looked at some of the evidence that was put before it and clearly recognized that there was enough resources in that regard. The court can always ask for input. Again, I don't see this as I see it as a sort of dialogical process of engagement in that regard. And I do also, my approach is not an inflexible approach. I never say, certainly in the book, I argue that the minimum call places a special duty upon the government to justify when it fails to meet the minimum standard. And that seems to me very similar to the jurisprudence that has been adopted, for instance, in relation to the right to privacy. In the right to privacy, where there is a failure, there's an intrusion into the very heartland of privacy that is the home, the court places a very strong duty on the government to justify it, any intrusion, and it still says we have privacy in other dimensions, but the duty becomes a lesser duty. And it seems to me that there's a similar point in relation to socioeconomic rights. One of the things that I'm concerned about, and this happens in all contexts where there are rights, is that it's very convenient and easy to say, well, there are no resources. And what seems to me to be required by having social rights in the Constitution is to place a special duty on government to justify and say, can we not afford to provide people in this country with enough protection from the elements? Can we not afford in this country to ensure that there's no malnutrition? Can we ensure to ensure that people don't have access to clean drinking water? And if you are going to say that, you have to show that you have an absolute scarcity and generally some kind of crisis that might come, for instance, through climate change, where there is a lack of absolute resources, for instance, in relation to water. But again, you need to try and plan for addressing those kinds of issues. And part of socioeconomic rights is to require that justification, and a particularly stringent justification where minimum standards are not met. I hope I've, to some extent, I mean, we may not fully agree still, but I've hoped to some extent express my perspective on this.
I just want to follow up.
Thank you.
I want to ask.
Commissioner Matolo, follow up?
Yes, you know, I understand you're speaking about this core minimum standard approach. You know, in an unequal country like we have, obviously, if we have to put standards, we have to take something from the other to augment to the other. So how do you think this can be done? I'm talking about issues about land. Already, if we have to take land from those who have it and reallocate it to those who need the land, obviously, that's going to be a challenge. So how do you see it? Because I don't like an abstract doctrine. I need you to give me, tangible things. Thanks.
Thank you, Commissioner. I think you're absolutely right that what the Constitution did when it entrenched social rights is it said to us that the level of inequality in South African society is not acceptable, and that actually we have to ensure in this country that there will be a redistribution to initially make sure that every single person has that minimum level, and over time we're able to address the full needs of individuals. I recognize, of course, one can't immediately ensure fully adequate housing, and there has a lot that's been done in this area. But ultimately, what we've said in our society is we're not putting rights simply on the paper, right? We are trying to give effect to those rights. And my goal in outlining the minimum core approach is to try and say, how do we make these rights meaningful for the people of South Africa? And yes, you're absolutely right. It requires the expenditure of resources. It may mean taking from less priority areas to more priority areas, but it places at the heartland of the political community the realization of the most basic rights of individuals in South Africa. And that's why I wrote that actually socioeconomic rights are in some senses political rights as well, because they require our community to attend to the needs of those who are the least well off in our community.
Okay, Chief Justice, I'll leave it there.
Thank you. Commissioner Marumwahai.
Thank you very much, Chief Justice. Good afternoon, Professor
Good afternoon,
Bilchitz.
Commissioner.
I have two questions for you. The first question that I have is with regards to Section 167, subsection 3 of the Constitution, which deals with the jurisdiction or the two ways in which one can approach the Constitutional Code. And I'm more interested on the second leg, which you have been referring to as a general jurisdiction. When one looks at the C part of that, it says the final decision has to be made on the issue of jurisdiction. It must be made by the court. The question that I have is, this jurisdictional point says there must be an arguable point of law of general importance. Given the fact that the decision is made by the Constitutional Court and not the person who's actually applying, because once you apply for leave to appeal or whatever, you are going to the Constitutional Court, you may believe that your case raises these things. What are the parameters that the judges who are deciding on this issue should actually look into to determine that if the matter is not a constitutional matter, does fall into this particular jurisdictional point?
Commissioner, the Constitutional Court has begun the process already of trying to develop the outlines of its general jurisdiction. And particularly, I'll refer to the Paulson case. And it outlines the different elements of there needs to be an arguable point of law, right? So there needs to be, firstly, it must be a point of law and not a point of fact. It needs to be arguable, and what are indicia of arguability? For instance, the court says if there was a disagreement between a majority or minority in the SCA, or a disagreement between two courts, or a narrow ruling in some ways, right? So arguability is something we have various indicia to tell us whether it's an arguable point of law of general public importance. So again, it can't just be a matter, the court has said this already, that relates to the individuals before the court itself. It needs to have general importance. It needs to be something that affects the South African community as a whole, or legal principle as a whole. It's not just about solving the case before you. That is matters for the other courts. And so that doesn't engage the jurisdiction of the court. And then the last part of that is which ought to be considered by the court. And the court has said that that includes the whole panoply of factors that come into a determination of the interests of justice. So there are a range of issues where even if we have a matter that's arguable point of law of general public importance, that the court will not hear the case on the basis of the interests of justice. And so those are the three elements that the court has developed in relation to the general jurisdiction. And I think no doubt this is relatively new. Obviously, it was instituted only about 10 years ago, and we will see the developments of those principles over time even further.
No, thank you very much for that. My second question is in relation, I've experienced in academia that sometimes as academics, we do research that speaks about the vulnerability of other people. And we do research because we want to influence policy or law that really assist in making sure that those people's unfortunate circumstances are addressed. But what I've realized is, as academics, we don't look at what we are doing within our own space and within the injustices that are happening within our own space. And I'm asking you this in relation to the transformation issues generally in academia. And I'm asking you in relation to the letter of Nadal. I'm not talking about all the other things. There's a line in that letter where they say the candidate's commitment to human rights and constitutional values needs to be probed, right? And I'm asking on that spirit. In academia, currently, I see that your first article was in 1998, as it seems here. And from what I see here, you have which is commendable, you have co-published with about 9 or 10 people. Those are the number of people that I came when I was looking at your work. Currently in academia, we have a challenge where we don't have Black female South African professors. What has been your role in ensuring that you, one, mentor, assist, and develop, particularly, and by Black, I'm not talking statutorily Black, I'm talking about Black people of African descent, because we are struggling to have those kind of female professors and I'm talking about full professors. And what has been your contribution? Because from your publication, it doesn't seem like you unless of course I'm wrong and you stand to correct me, of course, yes.
Thank you, Commissioner. I agree with you wholeheartedly that we need to do better in the academic community in relation to transformation on racial and gender lines. And I would suggest to you that my contribution has been in several respects in doing that. The institute that I direct, part of its whole goal is to nurture a new generation of public law academics with a particular focus on Black and female academics. And I have tried in my nurturing and mentoring, right? And that involves, as you will know, there is a long process involved. As the Chief Justice said, it took me 10 years of study plus another 8 years or so, and that's relatively quick to move up into the higher echelons of academia. I was mentored and provided with the mentorship to move and to understand how to become an academic and how to develop my skills. I've tried to do that as well for other academics, younger, junior academics in the sphere, and particularly Black and female academics as well. And we currently have at my institute an all-Black team, mostly female over the last period. And I have sought to nurture younger academics through that process of commenting on their work and a deep engagement. It's not just about saying, you must publish, because I don't think that's fair. I think it's about addressing the question of how do you write well academically? How do you reach those senior echelons? And I think that's really, really critical that we do that. I've also sat on the Constitutional Court Trust, and every year I volunteer myself to try and give people opportunities that I had to go and study overseas. And the Constitutional Court Trust has 2 scholarships, the Franklin Thomas and the Pius Lange Scholarship. One of those is particularly designated for people from previously disadvantaged groups. And I've tried to sit each year and assess the candidates, because I want to see that we get the best candidates going across to study, to learn. We have very good universities here. People can study and learn here, but also to study and learn overseas, to get that wider, broader experience, that they can come back to South Africa and bring that wider, broader experience as well. I've also co-written with academics and junior academics from from previously disadvantaged groups. For example, my most recent book, co-edited with a fantastic young academic, and it was co-edited with her, and is now and engages with the comparison, as I mentioned, between Colombia and South Africa. So I hope that satisfies you that I am committed to process of transformation. I think you are right. There are certain structural aspects which we still haven't got right. For example, I don't think there's enough postgraduate funding for individuals in South Africa to do postgraduate degrees, and particularly PhDs. I know the NRF, the National Research Foundation, has attempted to improve the situation, but it is still very difficult if you come from a poorer background in South Africa to be able to afford to be able to study in South Africa for a PhD. And it seems to me that those are the kinds of structural interventions that we need in order to advance and improve at the senior level the number of Black and female academics in our country.
Sorry, Chief Justice, if I can just wrap up this point.
Okay.
Because I think it's really important.
Okay, I just remind you, Professor Bilchitz, to try and be succinct.
Sorry, Chief Justice,
Okay.
I'm trying to give full answers.
Okay.
Prof. Bilchitz, when you were speaking earlier on, there's one important quote that you made. You said, who must do what for whom? And I'm asking you this question based on that. We have a challenge, and I specifically said to you, Black South Africans, and I'm talking about people of African descent. We don't have, I mean, in the country, the whole country, you'll be lucky if you can count about 5 full Black professors, right? And I'm saying you have been publishing from 1998 up until today. How difficult is it to have a Black South African mentor that Black South African? I've written with quite a few. It's not the most difficult thing. How difficult is it for white professors in this country? And I'm not pinning this on you. You know, it's just a conversation that I'm having with you, which I've had with my colleagues. How difficult is it for these white professors who have been doing this for years, and they have the skills to just pass on those skills, to co-publish with somebody, to show the person the journey of publishing, because we know how important it is in our, and I will leave it there. It's not an attack on you, please.
But just to say, even better, how much better not to just co-publish, but to enable someone to publish on their own and to become their own academic in their own right. And I've tried to do that in my work, I've had numerous success. I will tell you, I can't give you the exact statistics on, but we had in this last 6-year period, 65 units of publication produced by the institute that I direct, 37 journal articles and 14 book chapters. Many of those published by black female academics. And that is what I'm seeking to do, is to do exactly what you said, to try and share, impart, and enable others to do and to be able to achieve the highest echelons of the academic enterprise.
Thank you, Chief Justice.
Thank you. Minister, follow-up?
What I don't get from the prof, I may be a layman in that space of publishing. It doesn't come out clearly whether you have co-published with these female Africans that the prof is asking about. Have you co-published with them, or do you have such articles?
Yes, I have co-published with a number of junior academics, including with, as I've said, I've co-edited and published with just recently a black female academic with a book, and as well as an article before, and so that has indeed happened.
Thank you. Commissioner Makwanisha?
No, thank you very much, CJ. Good afternoon, Professor. I think as a follow-up to Professor Maruma Khai, I do think that it should be a very short answer. How many black female doctoral graduates have you produced? And how many black female postdoctoral graduates or fellows have you produced? It should be a very short answer.
Let me have a look at the statistics. In terms of PhDs, I've only supervised one PhD, and that was a white female PhD. There hasn't been a large PhD output. From 2016 to date, 5 of the 7 postdocs have been black, 6 of the 12 researchers are black, and 8 of the 12 female.
Thank you. In a response to the Chief Justice, you said that you have never been in any adjudicative role until recently. And yet you trained judges in Kenya and Tunisia. What were you training them on?
I was involved in the constitution-making process in Tunisia. And in that process, I played an important role in the placement of a limitations clause in the Tunisian constitution, which engages with when rights can be limited. And the giving effect to that limitation clause has been difficult in the political community. Hang
on, I must just intervene. The question is, what were you training the judges in Kenya on?
Oh, in Kenya, not Tunisia. No. I thought, sorry, I heard.
Both, I'm
okay.
sorry.
I heard Tunisia first.
Yeah, okay.
So in Tunisia, the training was on how to give effect to a limitations clause and on the principle, particularly of proportionality, and how to understand the principle of proportionality, what South African courts have done with the principle of proportionality, as well as I have some more global experience on the principle of proportionality. In relation to Kenya, there was a transition in 2000, and there was a new constitution and a whole process whereby there was a vetting of judges, and new judges came in around 2010. And as part of my work in the International Association of Constitutional Law, I went across as part of a project that I was involved in developing, and we trained the judges also on the limitation of rights and also on socioeconomic rights, and because these were relatively new in the Kenyan constitution. So with global experience around socioeconomic rights and around limitation of rights, and I found there was a very strong willingness amongst judges to engage with academics and to understand what the experience was worldwide in that regard.
Thank you, Chief Justice.
Thank you. Can I just ask a follow-up question? You see, to me, when you say train, it's like you were teaching them how to do the job, which in my mind is different from giving a lecture, like in a lecture hall, to say this is how you apply a limitations clause and so on. So which of the two was it?
Chief Justice, it was more smaller workshops, which was only with judges. We wanted judges to be able to speak freely and to engage. So it wasn't about a lecture. It was about providing input. So it was to the extent that I obviously couldn't talk to judges about writing a judgment on socioeconomic rights, but I could explain to judges what the different approaches were towards socioeconomic rights around the world, how issues around like that have been raised here around the separation of powers have been addressed, putting various options and perspectives, for example, on evictions law. South Africa's been very progressive in that regard. And the judges then were able to interact and ask questions about the jurisprudence that has existed around the world and how, for instance, we would suggest it could be applicable in the Kenyan context or the Tunisian context. So I hope that gives you a sense of what took place in those workshops. And as I mentioned, I've also designed a course for the Mexican judiciary as well around the content of rights and giving expression to the way rights are around the world.
So it was workshops.
I would put it more as workshops.
More like
yes.
that, okay, so that's all right. Thank you, Commissioner Matolo Tepu.
Justice, Chief Justice, I've done my part.
Oh, you're done. Okay, thank you. I thought it was a follow-up. Commissioner Nyami.
Thank you, CJ. Afternoon, Professor.
Afternoon.
The first question is in relation to the speed at which the Constitutional Court delivers judgment has raised some concern among South Africans, the delay in terms of judgments. We are fortunate to have an academic having started there as a clerk and now acting at the Constitutional Court. What can be done to address this concern, in your view?
Thank you very much. The first thing I just point out to you, as you've mentioned, is that, like, as a law clerk, the amount of cases that we got in new applications was incredibly lot lower than what's happened now. And that's partly because of the expansion of the jurisdiction of the court to a more general jurisdiction. And so I think, there are some statistics, there's some recent articles that have been written showing the major expansion of the workload of the court, particularly on leave to appeal applications. And I think that the solution really lies to a large extent in relation to leave to appeals and improving and streamlining the process in that regard. I think that the proposals that have been made by the Chief Justice require serious consideration about how, not that we don't need 8 judges to decide on leave to appeals. This is relatively unheard of worldwide, that so many judges decide on whether or not a matter which may have no chance of coming to the Constitutional Court gets heard. And that takes out a lot of time from judges, from writing judgments, and from being able to consider and reflect on the issues that they've heard and that they are deciding. So I think that is very important. I think perhaps a team, as I've mentioned, I think we should continue with the law clerk program, which has had a tremendous impact on South Africa. But I think also a complement with a team of experienced lawyers as well, who are linked to the court, as we had in a recent judicial exchange with judges in Canada, as is the case there, I think would assist the court and help us, in a way, speed up the decision-making around new applications. I think also there's implementation now happening of IT systems, which are important. I know the Constitutional Court now is implementing case lines, and I think we may see the opportunity for certain new IT possibilities. For instance, like Google Docs. I know when I write collaborative documents with people, we sometimes have a document where you can actually make changes directly, and a lot of people can work on that together. That may also help improve the efficiency of the court in advancing judgments. But ultimately, you have 11 judges. It's very complicated to ensure that everyone's perspective is taken into account in a judgment, and that will of necessity take time. And to some extent, it is also justifiable to take time to ensure that the right result is reached. Because once the Constitutional Court is pronounced, that is it. And there's no other appeal beyond that. And so we need to ensure that what comes out of the court is really something that is a quality product and gets the law as right as it can be and achieves the most just result as possible.
CJ, can I follow up on that?
Oh,
I'm
yes.
the side. Yeah.
Commissioner Ngwaitobi,
Yeah,
yes.
Professor Bilchitz, thank you for this answer you've just given. But what exactly is the problem at the Constitutional Court that is resulting in the delay of judgments?
Commissioner Ngwaitobi, as I've mentioned to you, I think the big issue is the relationship between the leave to appeal applications and the judgments of the Constitutional Court and the time that judges it takes away. So if we have less, for example, on the proposal that there would be 3 judges making a decision
I don't want the solutions now. I mean, I know that the solutions have been there because there has been a recent media exchange between law bodies and the Chief Justice. I want to understand a diagnosis of the problem. What actually happens? An application comes in, why is it not decided timelessly?
Commissioner, look, we are balancing many things. So let's say you have a hearing the next day. You are the final court of appeal. A matter comes in. You need to give serious attention to both the hearing that is the next day, and then you need to ensure that you fully understand what the issues are in the leave to appeal application. You not only have to understand what the issues are, you need to go and research the law relating it to see whether or not the SCA or the High Court or whichever other court it's come from, whether that law is correct. You then need to prepare a memorandum, and then you need to ensure that 8 other colleagues agree with what you've said, which of course also is difficult because there are there may be disagreements as well on that, on the question of whether to grant leave to appeal. And that's just one leave to appeal. We've now got 400 almost, if you think about it, in the year. And so therefore you've got you're trying to balance on the one hand the leave to appeal applications that are coming in with at the same time writing judgments, having hearings, and ensuring that you engage deeply with the law, as I've said, is required to ensure authoritative, clear, and quality judgments from the Constitutional Court. And so I think that what we see is that exponential increase has placed a huge burden on individual judges, and that therefore we have to grapple with how to address the solution and the institutional solutions, that 2 of which I've suggested.
Just for the last one, Chief Justice, and what have you found yourself I'm still trying to get a practical understanding of this. The reason I ask is because, I was also asked by Nadel, to look at that issue around the appointment of additional judges, let's put it like that, to help the Concord. But I was still not understanding what exactly is the problem. You see, for instance, in the SCA, they decide 1,000 applications for leave to appeal per annum, and they achieve a 96% decision rate. And they give much more judgments per annum than the Constitutional Court does, and within a short space of time. So I was trying to understand, if we are to be constructive, where exactly are we going to say the problem is? I mean, from your experience, have you written a note? So you get an application for leave, you've been allocated, you write a note to other judges. And what happens to it? Where does it get stuck in the system?
It's not a question of getting stuck, I think, Commissioner. I think it's a question of having the time to consider properly. Remember, as I've mentioned, the Constitutional Court is the final stage. So when you dismiss an application, that is the end of the matter. And so one needs to spend and apply one's mind with great diligence to when one refuses leave to appeal. And as I understand it, the difference between the SCA and the Constitutional Court is that the SCA, the matters are decided in panels of 2. And that allows for much speedier decision making, and it allows things to take place very quickly. where you have a panel of at least 8, and of course we were sitting last term with 10 judges, so all 10 judges are going to have a say on the matter. Each one of those judges needs to apply their mind to the matter on top of all the additional matters, and of course we each are writing our own new apps, plus other judges are writing their own new apps. And so it seems to me that the delay is inevitable when you have a system that is requiring at least 8 judges to agree with or dismiss a leave to appeal. And so I think the solution is, as I've suggested, reducing the panels and potentially having assistance to the judges with experienced lawyers who can help sift through those issues and do that research that I was talking about, so that we make the right decisions and that we hear the matters that must be heard and that are absolute imperatives to hear, but we also don't hear matters that don't deserve to be heard by the Constitutional Court.
Thank you. I think Commissioner Nyami was still
My
on the
last
floor.
question. Thanks, CJ. The comment by BLA, they praise you for your immense contribution to the legal profession, your academic writing skill and your publication. But they are of the view that you can benefit greatly if you can be given enough time to have an acting stint as a judge. I'll invite your comment on that.
I obviously would benefit. I think it's a correct comment. I would benefit from judicial experience, and as you develop the skill of judging, that one will learn, and experience is indeed helpful. At the same time, I think there are particular reasons why academics are appointed straight to constitutional courts. This is not just an unusual thing in Germany, in Colombia, around the world, right? And the reason is because academics bring, in a sense, a different experience, as I've mentioned, and also perhaps an experience of slightly being outside the system. And so the benefit of having an outsider view coming into the system, I think, can also aid and provide a fresh perspective and add to the diversity of the experiences around the court. So it seems to me that there's no doubt value in experience, but I think the experience that I certainly can bring is a different experience. And I would suggest that the experience of an academic is one which has the skills to be able to write judgments, to be able to engage with the deep areas of the law. And I have sort of engaged with those issues in response to other questions. And so I would suggest to you that I would be able to have those technical skills and competence, but obviously develop and broaden out as a judge over time. Thank you.
Thank you, Professor.
Judge Prim Lambo, a follow-up.
Thank you very much, Chief Justice. Prof, good afternoon.
Afternoon.
I just want to follow up on that because it's of interest to me to understand what your view is. This is your first judicial appointment, am I correct?
Yes, that is correct.
Well, do you think it would augur well for yourself as an individual to start at the first instance superior court, to apply your trade, to apply your experience and your expertise, then go straight to the top?
I do think that academics with a certain expertise are best placed in many ways to work at the apex court. And the reason for that is because, for some of the reasons I've mentioned to you, that I mentioned before, I haven't mentioned to you, sorry, Commissioner, but that the academics bring a expertise of breadth of knowledge from multiple jurisdictions, etc., and a depth of engagement with topics, and that those are the kinds of things that are needed, particularly at the courts that decide authoritatively, and the court that decides authoritatively. And I think here we can look at both the constitutional jurisdiction of the court, right, of the Constitutional Court, which is the guardian of constitutional rights ensuring the implementation of the Constitution. And I think there bringing in expertise from academia is extremely helpful around the underlying value and debates around rights. I've read some comments that there are very few constitutional cases that sometimes come before courts in some of the lower courts, right? And so therefore that expertise wouldn't be as much value as it is to the Constitutional Court. And around the general jurisdiction requires understanding the deeper principles and rules underlying the law and various other areas of the law, as I've said, partly require an infusing of constitutional understanding into those other areas of the law, but also benefit from the deeper philosophical engagement, deeper comparative experience that an academic can bring. And so I think it is, and that is why I think this is the practice in other jurisdictions as well, that academics are perhaps particularly well placed to engage with the deeper principles of law, to engage, not that academics don't do good jobs in other courts. I know many of my colleagues do act in other courts as well, but I think can actually, particularly with an expertise on constitutionalism and with an engagement with the deeper underlying principles of law, can go to the highest court without necessarily lacking something which is needed. And I think that complements the judges who have been through the system and who fully understand all the elements of the system that their experience has indicated. And so for me, it's not about one being better than the other or one or the other, but it's about a complementary skill set that comes in and advances the judgments of the court and the substantive values of the court. And that is one thing I do want to say as well, is I do think one aspect that academics have is a very strong focus on the core issues, the core substantive questions. And of course, to some extent, that means there may be a degree of lack on some of the procedural dimensions, but I've also experienced to some extent that procedure can in some ways hinder substance. And so I think that balance between those with deep procedural expertise, understanding all the ways in which the courts work.
Succinct,
Sorry,
Bilchitz, try and be succinct.
Yeah, I was sorry, I disturbed the CJs who were stopping me. I was going to do the same thing. I had a court which fields the lion's share of the constitutional cases that come to the South African courts. I've appointed, not me, sorry, the minister. I've recommended a number of, I would call them academics for want of a better word, to do work in the division. And the overall comment from them is it has enriched them a lot better to be steeped in the first instance intricacies of litigation, especially constitutional law litigation. Hence, I asked you the question because you seem to lean on the school of thought that says there are academics who are just fit to go straight to the top. And I have heard of some academics that I've approached, they haven't said so directly to me, who have not accepted those invitations because they want to go straight to the top. Do you have a comment to that?
Judge President Lambo, as I've mentioned, I think there are many academics who will do a wonderful job at different levels of the judicial system and who will also benefit from that as well. At the same time, as I've suggested to you, and I don't know if I can take the point much further, but I think that individuals with specialized constitutional expertise who view matters through the prism of the Constitution and who have a deep engagement with both the deeper underpinnings of the law and the values of rights in the Constitution may well benefit the Constitutional Court. and that also there are different trajectories involved as well. That some academics that there is a trajectory of moving
I think
through
you've
the
answered my
judiciary.
question.
Sorry.
I don't want you to repeat what you said earlier.
Yes.
Thank you very much, Chief
Thank you.
Justice.
Thank you.
Chief Justice,
Thank
may
you.
I follow up on that, please?
Yes,
Thank you.
Commissioner Play.
Good afternoon, Professor Bilchitz.
Commissioner.
Earlier, and I thought I misheard you earlier, but I think you've just repeated it now. When you were asked this question around 174.5 and why, in your view, academics are, in your words, best placed to assist the Constitutional Court, you raised three factors. You spoke about the range of exposure to other jurisdictions, which I think you particularly have. You spoke about academics engaging with younger people. And you spoke about what you called the depth of engagement, and that's getting into deeper underlying issues. Now, I just want to check, you're not suggesting that the non-academic candidates for this position, including very highly experienced judges, highly experienced practitioners, are not able to meet these three criteria?
Commissioner, I think I was trying to underline, not to indicate what others don't have, but what academics have to bring. Academic expertise is not exactly the same as other forms of expertise. I think that is very important to assert. It's a different form of expertise. I could have chosen to go a route of being an attorney or an advocate and be appointed as a judge, potentially, and that would have been a different route of a legal career. An academic career brings with it certain advantages and disadvantages. And no doubt colleagues who have, as we know, we've got very experienced judges, we have very experienced advocates who are before you, and they have incredible expertise and would be incredible appointments to the Constitutional Court. But they don't have the same expertise as myself. And the key is to distinguish, and that's what I suggested to you, it's distinguishing the difference between the expertise, right? And I think that's what I was trying to grapple with and develop as an argument of what can an academic particularly bring.
And that's exactly what I'm probing with you, Professor Bilchitz, is this so-called point of distinction. What I'm putting to you is, and you drew it again in your answer earlier to JP Mlambo, you drew a distinction between what you call deep substantive knowledge and deep procedural knowledge. And what I'm putting to you is that that distinction is illusory. Given the kind of candidates we have before us, we've got highly experienced judges who've practiced in other jurisdictions, who've got that deep knowledge of the Constitution. We've got extremely experienced practitioners who have experience on the bench and in practice, who clearly have a strong academic background, and therefore also have that deep understanding of the Constitution. So what I'm probing is what you seem to be putting forward as a distinguishing factor, which clearly doesn't seem to be the case.
I disagree with you. I don't think, and I'm not seeking to, as I say, cast any aspersions on any other candidate. But there is a difference between people who spend their life researching and working on issues around fundamental rights and people who take particular cases, and I'm not knocking this expertise, but try and marshal the evidence for their clients as far as possible to deal with to give the best possible case for their client. And I have noticed in the Constitutional Court, from my own experience, that now, having acted, that there is in fact a lack of depth at times in the submissions that are put forward, and a lack of the ability to engage with those deeper substantive underlying questions that relate to what conception of privacy are you engaging with? What approach towards socioeconomic rights are you dealing with? How do you justify some of the elements? The issues remain at a particular level of doctrinal engagement. And I'm not saying we have incredibly smart, brilliant people who are also candidates. Their experience differs from people who spend their days working and researching around both comparative law, both the substantive and philosophical dimensions of law, and that I have seen that in my personal experience, that I've had something to give to other colleagues and they've had something to give to me. And so I think it's really important to recognize that individuals who, there are maybe, and there are some here, brilliant individuals who have written books, for example, as well, and who've spent the time research, and they will perhaps attest to the difference between writing a book and writing a brief before the constitutional court. There is a difference, and I've tried to capture that through that reference to the depth, to the ability to connect different ideas, to explore and excavate the underpinning philosophical justifications underlying that, to make connections that you don't necessarily need to make, and perhaps one element is the imagination, the constitutional imagination that an academic can do without working within the four walls of the particular system itself. And I think that's an important distinction, that one is working often as an advocate within the system in a lower court, often with the precedent that comes down at you, but without having to actually develop and suggest what is the best way in which the law can build, can be realized. And that's what academics do. They spend, or the academics who are similar to me, how do we best give effect to certain of the deeper values of the Constitution in particular areas? I hope I've tried to convince you of that.
Not necessarily, but let me put my last concern to you, talking about working within the four corners and working within the rules. You've spent a lot of time today trying to persuade us that your viewpoint on the core minimum content is in fact the correct one. But we know that the Constitutional Court has repeatedly indicated that it does not rely on core minimum content, and it does opt for what you call the reasonableness approach. And in very well reasoned judgments, repeatedly. You accept that the die is cast as things stand, and that you work within those parameters if you get to the Constitutional Court?
I think the answer is a complex one. The first one, and I think that is a big difference, as you've said, is that the role of precedent as a judge is much more powerful. And one can't simply come into a court and overturn a long history of development because you have a different theory or you think your theory is better. And so I think that respect for precedent is an essential element. And I think, as I said, this is one of the distinguishing features of academia, being able to stand outside the box and actually say, what are the problems with the routes that we've gone down? And academics doing that, but then with your hat as a judge, needing to respect the precedent and not overturning and creating continual revolutions in the law. And so there's a balance, right, that's going to be achieved, that needs to be achieved between, on the one hand, recognizing, and the Constitutional Court itself has, right, I'll point out, for example, recent example, the Bwania case, which overturned the case of Fawkes versus Robinson, which was widely criticized in the academic community, and the Constitutional Court overturned that case. It is possible to overturn, for the highest court to see that it's going down a route that is not a productive route or not one that achieves justice. On the other hand, one could strengthen and improve existing jurisprudence so that perhaps something like reasonableness takes account of some of the critiques without jettisoning the precedent that's involved and that the court has developed. And so my role as a judge would be to give due regard to precedent, not just to impose my theories that come and that I've engaged with in terms of thinking about how best the law could be, but to also inform how we develop the law. And that's the key issue at the constitutional level, is that the law is not totally fixed. And how do we develop substantive law in this country, that it achieves the goals of our constitution and substantive justice for all South Africans?
Thank you very much. Commissioner Nochesi,
Thank you.
can I move on?
Is it Commissioner Nochesi? I think he will allow me to step in.
Commissioner Nochesi, to give up your time to Commissioner Bajovi?
No, you will have his time.
Commissioner Nochesi, okay.
Yeah. Good afternoon, Prof.
Good afternoon, Commissioner.
Prof, I only have two questions. First, you admittedly say you are only an expert in constitutional law, and all your Articles 27, they are on socio-economic rights. That's what you have written about, mainly. Now, in fact, you written on constitutional law, let me put it that way. The comments in recent years has been that the depth of judgments coming from the Constitutional Court, in particular in the area of private law, needed to be balanced. And you seem to bring nothing in that area. There's simply no value that we are bringing. Secondly, you only acted, as it has been said, for 2 months. I'm not too sure whether it's 2 months. No judgment you have written at all, not a single judgment, where we can objectively assess you, other than your own promises that, look, I'm fine, and then all that. And lastly, you say, in terms of Section 174.5, well, academics must go, must be taken, which is correct. But I'm not too sure whether your interpretation of that section is correct. That you take any academic, you ignore all the other considerations. What objective evidence do we have that if you are appointed to the Constitutional Court, you will be able to hit the ground? As we know now, we are not an all-rounded judge. We are only somebody who specializes in constitution. If you can answer, I would request you, Prof, so that we move faster. We don't get, and this question has been debated, but I just want to get, some Africans there are watching. Here's a judge who has not a single judgment. What is justification for your appointment, other than to say there's Section 174.5?
I would suggest to you the record of my writing and what I've been involved with is what you would need to assess in relation to whether I'm able to do so. I suggest that there are quite a lot of similarities between, they're not exactly the same, but between academic writing and judge making. You need to marshal a lot of evidence. You need to listen and engage with different points of view. You need to be able to structure an argument, and you need to be able to provide a point of view. And I would suggest to you that those are, I cannot, as I've said to you, point to a judgment, but I can point to what my writing says. And I would also just like to suggest that my record isn't only on socioeconomic rights. I hope I didn't give that sense. I've written on business and human rights. I've written on LGBTQ human rights. I've written environmental rights and animal rights. I've written on a limitation of rights. No. So I've written on a lot of things, and also on areas of private law.
Sorry, Prof, I understand. Your answer is that we must look on the articles. That's the answer to what my question was.
That would be the evidence of that you have.
The second question. The ICJ in 2004, specifically it's 9 July, that is 2004, on a pertinent question about Israel and Palestine. Make this on a pertinent, this is a decision of that court, and this is a finding they make. I want just to read one sentence for you. The court concluded that the construction of the wall, along with measures taken previously, severely impeded the exercise by the Palestinian people of its right to self-determination, and was thus a breach of Israel's obligation to respect that right. This conclusion had followed a finding that the creation of this wall was tantamount to a de facto annexation. That is 2004. Now, come 2019, you write an article. Your article which says creating a different future for Israel and Palestinians. Are you aware of that? You remember that article?
Yes, I do. Thank you.
I want us to talk briefly on that. And correct me if I'm wrong. The impression I get from the article is two. First, you criticize the comparison of the actions by the Israel government with those.
Sorry,
of-
Commissioner, not JSC. I assume that that's an article that's in the bundle.
Yes, yes.
Okay,
That's an article. Yes, that's
Okay.
an article. In fact,
Chief Justice, I'm not sure if it's in the bundle, but I just want to put on record that we did give Professor Bilchitz notice that questions will be asked about his article.
Okay, no, that's all right then. Thank you.
now, in the article, in parts, this is what you say. You say, I mean, this is what, this is an observation. I mean, you criticize the comparison of the actions by the Israel government with those of apartheid South Africa. You describe the comparison as nonsense if one considers the different origins of the conflict. Were you aware of this decision of the ICJ of 2004? Because in the judgment, you simply make not even a single reference to it.
Commissioner, I'm very willing to answer questions about issues and my prior writings relating to Israel-Palestine. I would, though, like a direction from the Chief Justice if this is appropriate for me to do so. I am aware that the former Chief Justice was disciplined by the Judicial Conduct Committee for expressing views relating to the Israeli-Palestinian conflict. And I am currently a sitting judge of the Constitutional Court, and I've taken the view, ever since I knew I was an acting judge, I have expressed no view on any conflict that involves foreign policy, that involves the domain of the executive, and I've tried to conduct myself in that way. I am very happy to defend what I said and what my views are, but I'm also not sure that I'm entitled to do so. So I will ask for direction from the Chief Justice in that regard, and if I'm permitted to answer your question, I will do so.
Yeah. Now, just before the Chief Justice answers, I'm asking this question based on your article in 2019 in view of the judgment of the ICJ, of which the starting point was to establish if you were aware of that judgment of the ICJ when you were writing this article.
Absolutely.
If we can agree on that.
And I would suggest to you, just in very broad terms, that my general record in regard to writings on Israel-Palestine, and I don't think that is at all different from that article, is that I accept international law and I seek to give effect to international law in everything I've written in relation to Israel-Palestine, to defend the rights.
Professor Bilchitz, you wanted me to give guidance. You have started giving an answer before I could say anything. Well, one, I thought that at least the question that had been asked to you was simply limited to whether at the time of writing the article you were aware of the judgment, which didn't seem to me should create any problem. But to the extent that there might be another question that you might be uncomfortable responding to without guidance, then one could take it from there. But the one about whether you were aware or not didn't seem me to be problematic.
Absolutely. As someone writing in the area, Chief Justice, I'm very aware of that judgment, and I would suggest to you that the article is in fact completely in accordance with that judgment by highlighting the various injustices in relation to the military occupation of occupied Palestinian territory in that article that I seek to draw attention to.
Yeah. Lastly on this, but if you don't want to, if you are not comfortable to answer, you can say so. The immediate impression in the article you wrote in 2019 is that, in your view, Israel is not a colonial settler. That is the view that I make. Is that fair?
To answer your question would be to wade into a highly contested engagement with issues of history and politics, which I think would be inappropriate for me as a sitting Constitutional Court judge to answer. I would just make the point that my record in this regard is to, one, defend the role of international law and try and ensure that it is given effect to. Two, to defend the rights of human rights of Israelis and Palestinians, and to try and utilize the South African experience to try and understand how one brings people together from very, very, very different histories and narratives to find some kind of resolution and negotiated settlement. That has been the impetus of my work in that area, and I would suggest to you my work has tried to give effect to the values of our Constitution and broaden that in international.
Don't go too far, Professor Bilchitz, if you say you are uncomfortable. If you go too far, you may be opening yourself up for further questions.
Thank you, Chief Justice.
Yeah, this is the last third question, Chair. It's two issues that were taking long. This is a third question.
I want to make a follow-up on the question before you go to the third one.
The one that is uncomfortable to answer?
Yeah.
And then he will say if he's uncomfortable with your one too.
No, I'm just saying the question is based on the article he wrote.
Yeah.
And we're saying to him, we're putting it to him, that it will be our interpretation that you are saying Israel is not an colonial occupier. And if he says, I'm not going to comment on that, that remains our opinion and it will be raised in deliberations.
Well, maybe what we should do is excuse the candidate briefly and let's talk among ourselves. Is it fine? Let's just do that before we proceed. You'll be called back, Professor Bilchitz, and will the media also please excuse themselves? And other people. Welcome back, Prof.
Thank you, Chief Justice.
Thank you. We have had a discussion, and the position is that you are being asked questions about a view you expressed some time back, and not as a judge. And clarification is being sought so that it can be determined how, what weight should be attached to that view for if any, for purposes of deliberations. And it's fair that you be given an opportunity to clarify. So, but if you are not comfortable to answer, you won't be forced to answer. But the commissioners who may have sought clarification would then deal with the matter without the benefit of your clarification. Okay, all right, thank you. Now, Commissioner Malema, you wanted to follow up, or you wanted that question. That's when we excuse the candidate. I think I must give you a chance to ask your question.
No, Chief Justice, I was not asking a question. I was just repeating what Commissioner Nonchesi said, and he said it's uncomfortable responding to that. So I was saying to him,
yes,
if that is the stance, it means in the deliberations, I will be allowed to express that view as a correct view because you didn't put a counter argument or seek to clarify it.
Yes. Thanks. No, thank you, Commissioner Malema. Just to make sure that we are on the same page, Commissioner Nonchesi, do you want to put that question again to the candidate so that he can then now answer if he is comfortable or to answer, but also knowing what the consequences will be if he doesn't answer, namely that commissioners would look at the matter, consider the matter without the benefit of his clarification.
Thank you, Sir. What I was saying to you, Prof, is this. The total impression of that article is that you suggest that Israel is not a colonial settler in Palestine. I mean, it's not an occupying state. That is the total sum of what one gets.
As I've mentioned, I do not want to wade into a matter that is of deep controversy at the moment in the South African community. I would hope people who are Zionist or anti-Zionist or post-Zionist would have faith in me to address issues if they ever come before the Constitutional Court in an impartial manner. I would suggest to you, the only point I'd like to make in relation to the article is that when I brought a delegation from Myanmar, I engaged with some of the senior members of the ANC who negotiated South Africa's settlement. And they said to me, despite not seeing any justice in what the Nationalist Party had to say, they tried to think themselves into the perspective of those who they had to negotiate with and tried to understand what is the deepest fears they have and how can we find a way through that. And I would suggest to you that my work, and that article in particular, is an attempt to say where there are deep divisions, contesting narratives, which are really landing up in an absolutely horrific situation we all watch at the moment, an Armageddon. How can we find a way through? How can we listen to each other and our different stories that we have around Israel and Palestine to find a way that the people of that area can share the land and share a future together? That's what I've sought to do. I've tried to be a peace builder in my work. I've tried to engage with peace in Colombia, which is a place which...
Sorry, Prof, you have answered my question.
Thank you.
I think I should end here.
Sorry, Commissioner JSC.
I think in view of time, I must stop here. Other commissioner will follow. Thank you.
Just a follow-up, CJ.
Okay, thank you.
CJ, follow-up.
Oh, Commissioner Malema?
Yeah, mine is very simple, Prof. Do you still stand by that article?
Mr. Malema, I'm not sure I would write every single phrase in the way I did. I shift my own views as well. But in large part, the necessity to find a way through, to understand the two very divergent and competing narratives, and to find a way for the two peoples to listen to each other and to live together in peace and dignity with respect for self-determination and international law, those are all things I would still stand by.
Prof, do you still stand by that article? Because it can't be, you can't have it both. It's either you say there are parts of the article that, given the new information exposed to me, I will rather not keep in that article. So if you stand by it, just say so. So when I leave here, I know Prof still stands by that, or there are these other parts which, with more information and hindsight, is no longer standing with those.
Commissioner, I stand by the thrust of the article, as I've said to you. I think there are changed. We had seen differences over the last 5 years. We have also seen there are currently, and it's not right for me to express an opinion about proceedings before the International Court of Justice at the moment on a number of questions. And as I said, as someone deeply committed to international law, I would also see myself as bound to shift my views if the International Court of Justice finds in certain ways that require me to shift my view. But as I say, I'm not able to express my view on those things. That's inappropriate for a judge sitting in the Constitutional Court at the moment to express views on proceedings currently in an international court, and those may have caused some change to some elements of the article. But the thrust for need for finding a way through to peace, I stand by.
Sorry, Chief Justice. Sorry to interrupt, but you know, Professor Bilchitz, when I first raised my hand 3 hands ago, I wanted to ask you a question about contract, but I'm now going to ask you a question about this thing that's being debated. The reason is because, you know, I always watch candidates here before the JSC. They are asked a relatively inane, mundane question. They complicate their lives, you know, by appearing to be defensive or evasive, etc. Now, I'm afraid that is the impression I'm getting around this issue. And, you know, and it's not a complicated question. You wrote an article and you said you don't buy the story of apartheid, you don't buy the story of colonialism, right? That's fine. We can have debates about that, and apartheid is an international legal issue. And occupation is also an international legal issue. We do need the views of our top judges in the Constitutional Court on these questions, because South Africa is engaged in the international space, and it has been engaged since 1994. It can't avoid it. So this idea that, you say, well, there are certain things have moved along, it gives the impression that you are evading the issue.
Commissioner, I think that's really unfair. There is currently, as you know and you have argued, there's a case currently before the international...
Hang on, Prof. Hang on. When Commissioner Ngwetobi says this to you, to say what you are, the way you are responding gives the impression that you are avoiding. It's to your benefit, because he wants to give you a chance to say to him, no, I'm not avoiding, and here is why you shouldn't think I'm avoiding. You persuade him. So he's giving you that benefit. If you don't explain that, he's going to go into deliberations with the picture that you are avoiding. So he's trying to make sure that he's fair to you.
Thank you, Chief Justice, and I apologize if I appear evasive. I do not want to be evasive in any way. I do not see it, and I take that view as appropriate for me to express a view on proceedings. There's currently proceedings which South Africa has brought relating to genocide before the International Commission of Justice, and there's also an advisory opinion that has been requested on questions around occupation and apartheid. I see it as inappropriate for me to answer questions about whether or not this is correct when South Africa has a live case and live interest in that, and the principles are being discussed at that level. As an academic, I would love to do that. I'm not currently just before you as an academic. I'm before you as a candidate for the Constitutional Court and acting as well on the Constitutional Court. And so...
No, Professor Bilchitz, I'm sorry. I think that the problem that I'm grappling with, you were not here when we had a break, but Commissioner Malema made an example and said, if you just asked JP Mlambo, what do you think about Israel versus Palestine? Without anything, he would be entitled to say, I've not actually formulated views. In fact, I'm very surprised that you're asking me that question. Can I please get a pass? But he was saying, what is different with you is that you have, in fact, written an article, right? And you have expressed these views. And so many things have happened. And we just want to get a sense that, all right, this is the view you expressed, this is the view that you take. And that's the only context in which I said, should I not be worried that you are evasive? Because this is not something that you are being asked for the first time. You have written about it. So is this the view now that you carry with you in the Constitutional Court as a future judge? And these things are actually very simple. No one is trying to catch you. In fact, personally, I'm actually I was looking forward to this interview. And I thought this question could be dealt with within a minute.
Well, I'm not sure how I can deal with the question in a minute, but Commissioner, as I've said, I'm not trying to be evasive. I've made perspectives in the past. I have expressed where I stand in the past on these things. At the moment, since I was appointed as an acting judge, I have not commented on the last 6 months of horrific events that have taken place in the Middle East, and I've said nothing for exactly the reason that I believe it would be inappropriate for me to wade into that territory, and that people in South Africa with vastly different points of view should be able to have confidence in me, and that I will fairly, and I think the key thing that needs to be understood is my commitment to fundamental rights. I've defended that in everything I've done, a commitment to international law, which I've defended in everything I've done, and a commitment also to finding ways through to peaceful resolutions of intractable conflicts.
Thank you very much. I think we move on. I've got 2, 4, 5. That is Commissioner Klaba. I don't know whether Commissioner Malema is still going to want. Then Commissioner Dodovu, Commissioner Breitenbach, then Commissioner Mangena. I propose that I should not take any further hands. I should just exhaust those. Commissioner Klaba?
Thank you very much, CJ. My questions have been exhausted. I only have one question.
Okay, thank you.
Just for yes or no answer. Prof, do you hold a dual citizenship?
I am only a South African.
Thank you.
Thank you very much. Commissioner Malema?
Thank you, CJ. Just a quick one, Prof. So I think we are in agreement that you don't have experience as a judge. For the record, Prof.
That's correct. I have only been acting as a judge for the last 2 months.
So now,
yes.
if I'm presented with a Black African male who comes with a huge experience of a judge, including good judgment writing, and Shemis at your level, it's you, except that you don't have experience, but also this judge, because I don't buy this thing that only academics can write very well. So for you to be a good writer of judgment, you must be an academic. We've been having very good judges writing very good judgments, and they are not academics. So then through the judgments of this judge, you can see that it's very good. So when you are confronted with that kind of a situation, what do you do?
Thank you, Commissioner Malema. The key,
in line with transformation, yes.
Yes, absolutely. The key provision is Section 1742 of the Constitution, as I'm sure you're aware, which says the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered. In light of our history in South Africa, it is an imperative to have racial and gender transformation. And so I would think there would be a degree of preference towards the black male candidate or black female candidate even higher in many ways. What I can offer is, as I've mentioned, a diversity of perspectives, and also perhaps one element of diversity that hasn't really been canvassed thus far. And that is that when I was growing up, people with my sexual orientation were criminalized for having same-sex relationships. And during my lifetime, the Constitution has fundamentally changed my life and that of others in the LGBTQ community, first by decriminalizing our sexuality, and then recognizing our rights to stand shoulder to shoulder with other South Africans in dignity. There are still very few openly LGBTQ judges in South Africa and in fact around the world. And I remember how deeply moving for me it was to see the first Constitutional Court judge, Justice Cameron, appointed to the court. Why is it so important? Because I think when we look at Section 1742, we want South Africans to see themselves in the court. And so I would hope that my appointment would in some sense advance LGBTQ representation and also perhaps serve as an indicator to the young lesbian woman I met last year from Katlehong and the transgender activist who I met who was rejected by their religious community, whose families have refused to accept them and for whom they've been rejected, and who opened up to me about their own pain, that the South African legal and political community seeks to embrace people with diverse sexual orientations, and that she and they and others like them, whoever they are and wish to be, can be authentic in their own identities. And so I would suggest to you that there may be other elements of identity, such as sexual orientation, such as disability, which may play a role in the deliberations of this commission.
Last one, CJ. I'm a very, supporter of LGBTQ community. I'm the only president of a political party who marched to Uganda wearing a rainbow flag, because that is a community that I feel very strong. It needs to be supported. You have all what it takes, Prof, except this fundamental issue of experience. And you just joined a church. And then after joining the church, the next thing you're asking is, where are the pastors sitting? Just on arrival. Don't you think that is unheard of?
Commissioner Malema, you point out, of course, my lack of judicial experience, but I am an experienced professor. I am still young, like yourself as a political leader, and I think we're a young country in many ways. We also have a young Minister of Justice and many young people who committed to advancing this country in the different ways that we have to do that. I agree with you. I lack that experience, but I have a different experience, as I've suggested, which is what I need to be considered on the basis of. So it's not something that I can say to you. I can manufacture judicial experience that I don't have. That's something I don't have, but I do have all these other things. And if you think the things that I have can enhance the Constitutional Court, then that's the way in which I put myself forward for the court on the basis of what I do have. Thank you.
I'm very sorry to do this, CJ, too, but why can't you? Because
maybe Commissioner Malema, because I wanted to say something about the question you put to him. If I can just say something before you continue.
But maybe before you say that, so that you can enrich what I'm going to say.
Okay.
Why can't you just say, okay, this is my weakness. Let me go and work on it. And we ask Chief Justice, I don't know who else, the powers that be, to give you more acting stints. And you just said you are young. There are people who self-disrupt. Don't self-disrupt. You are young. There's nothing against you except this element which is workable. You go and work on it, and then you perfect it, and then come back here. And you're like, your interview is going to last for less than 30 minutes when you come back because we've asked you everything. But you say, if this is a fair criticism, I accept, let me go and accumulate more judicial experience. Thanks.
Commissioner Malema, that is one possible route. And of course, that is one possible way that my career could unfold. My caution about that route is what it does is it requires, in a way, it says to academics, your only route to the judiciary is in a way by shifting your career from academia into the judiciary. And in a way, already my university is required to find replacements for me and has been very, very kind, the University of Johannesburg, and always very supportive. But what it does mean is that the academic loses their academic dimension and becomes more of a judicial figure, and then only can get appointed. And I think part of what I've suggested is that if you want that fresh academic perspective, in a sense, partly outside the judiciary, then it's possible that it's not a weakness that one doesn't have judicial experience. One just brings something different to the experience of being a judge. Thank you.
Well, I wanted to say, Commissioner Malema and Professor Bilchitz, that Professor Bilchitz chose not to say to Commissioner Malema, you see, Commissioner Malema, I was at the university going on with my business, never thinking about acting in the Constitutional Court until the Chief Justice phoned me. and when he phoned me, he said, the only people you would give an acting appointment if they were academics and senior practitioners would be people who would commit themselves to making themselves available. That's why I'm here, So I just want to say, in part, it's the Chief Justice who has encouraged them to make themselves come forward, make themselves available. Of course, that doesn't necessarily mean that they, if necessary, further acting stints can't be given. But I'm just saying the context is that they were minding their own business until the Chief Justice phoned them. Okay, thank you.
Thank you, Chief Justice.
Thank you. Commissioner Dodovu.
Thank you, Chief Justice. Good afternoon, Prof.
Good afternoon, Commissioner.
It has been a long session for you. Now, on your own accord and evolution, you gave some practical examples of how the Hood bomb case was handled. And you said to us that you were doing your clerkship at a time that the matter was heard and the judgment was delivered. I want to traverse with you on that particular case. I'm doing so because of one specific reason, and the reason is that you said, as I listened to you carefully, you were totally not satisfied about the whole judgment. Now, I know as much as you do that the matters that come before the Concord or its decisions are res judicata are binding, are final and binding, and you cannot go beyond the apex court. You know that, and I do. Now, what are your specific concerns about Groot Bomb case that you would want to share with us here as a commission? And I'll make follow-up based on what your response is. Thanks.
Commissioner, the Groot Bomb case, which I was in fact a clerk on, was concerning for me for the approach that it adopted towards socioeconomic rights. So although actually I think it's one of the more substantive cases, if we look at in hindsight, that the court has given, the court focused a lot of its attention and its attention on the reasonableness idea. And it said that our duty as the court is to establish whether there's reasonable legislative and other measures to achieve the progressive realization of the right. And it essentially found that the failure to make provision, the government came and said, well, we have a housing program for the longer term, but it didn't make provision for people who were on a field with no roof over their head. And what the court said is that's unreasonable. And I wanted to try and understand what underlies the unreasonableness of the failure to make provision for those who lack a roof over their head. Because I found it a vague standard which doesn't really provide guidance to courts, to other branches of government, and it really removes a sense of what the content of the right is. And actually what I think the court was saying is that there is actually a minimum requirement that you need to ensure that everyone has a roof over their head and is not in desperate circumstances. And it actually could have gone to the right itself, to section 26(1), the right of access to adequate housing, and it needed to put a complex relationship, recognizing that reasonableness is about the legislative and other measures that to achieve the progressive realization of the right. And the court needed to say more about everyone has access to adequate housing, that adequacy at least means access to a roof over your head, basic services, etc., what the court developed. So my worry is the lack of engagement with the content of the right.
But Prof, as you know that this is a seminal judgment. It gives direction and meaning to how Section 26 of our Constitution must be implemented to ensure right to adequate housing, as you say. But equally important, it also gives effect to Section 152 of the Constitution that spells out the objectives of local government in terms of what is it that it must do. But you say you have specific issues with that. And other than saying the reasonableness that you are explaining, you don't spell out in precision what exactly do you have problems with, because this particular judgment, as seminal as it is, as landmark as it is, it has given a practical meaning in terms of forcing government to develop programs that support the poor and give the poor shelter over their heads. And I don't understand. Can you just clarify that better?
Yes.
In a way that I will understand where I see that.
So my worry, Commissioner, about reasonableness is that actually, as you've said, it actually, that judgment did have some impact on government policy in terms of the passing of an emergency housing policy. The order in that judgment was also very weak. It was a declaratory order and didn't order any particular specific things to actually occur in some ways. And one of the critiques that's been raised is that Mrs. Groot Bomb never actually got a house at the end of the day, and she passed away sadly without that. But my main problem relates to, and it might sound very academic, but the way of approaching socioeconomic rights. Let me try and explain to you why that's really difficult. Is that what the court essentially said is, when we look at social rights, we're going to evaluate the reasonableness of a government program. And I was involved a little bit with some civil society organizations. And you need to come to court instead of simply showing, I don't have food, I don't have housing, right? Which many other jurisdictions, that's the basic. A litigant must come to court and show, I don't have adequate housing, I don't have adequate food. Instead of doing that, in South Africa, you need to show a hell of a lot of complicated things. You need to show that the government in its whole housing program is unreasonable in the way it is giving effect to those rights. And that involves evidence, it involves social science research, it involves a whole lot of aspects which make it very difficult to get access to rights that you wish to get access to.
Thank you.
Yeah.
It's okay. Thank you, CJ. I'm covered.
Thank you very much. Commissioner Breitenbach, I'm not sure whether you said you were covered earlier on.
Thank you, Chief Justice. I am covered.
Thank you very much. The last one is Commissioner Mangena.
Thank you, Chief Justice. Good afternoon, Prof.
Afternoon.
Yes. At some point, I thought I would let this question pass. But there is a nagging edge to put it to you. In my student days, I was an ardent supporter of academic freedom because I believed that academics should be free to express themselves without any form of restraint in the process of knowledge production. Now, but here's my problem. You are an academic, and in the judiciary, there is something called judicial restraint and judicial temperament. And with you seeking to sit in the Constitutional Court, where you are going to sit with about 10 or so judges, and highly opinionated as you are, you strike me as someone who's highly opinionated and believing in this. Once you believe in something, it's very difficult to let go. And that's the impression that I got since this morning. Do you think that you possess a necessary temperament and restraint to work together with other people to a point where there would not be unnecessary delay in judgment production because judges are held to, for lack of a better word, ransom in dealing with academic issues instead of legal issues? Your comment, please.
Thank you very much. I think you've put your finger on like a big difference between academic writing, as I've said, and judicial writing. Judicial writing is by its nature more restrained, more minimal in its nature. It needs to say what's necessary, the reasons that are necessary to reach a decision. Academics, as I've tried to show, go deeper. They tend to uncover various reasons, connections that you wouldn't necessarily make in a judgment. And a nice example of what you're saying is when I was a law clerk, I wrote a memorandum for Justice Langer on a matter, and he looked at it and he took a paragraph and he said, I really like this paragraph and I want this to utilize it. He said, but the rest is for your book. And I think that illustrates very nicely the distinction between the two different types of writing, that there are more constraints in judicial writing. At the same time, there are also constraints in academic writing, of course, by length and polish, etc. And you asked me, can I make the transition? I think yes, I can. I mean, I think that it obviously there's still, as you've said, you need to still look at what comes out. But I have already acted on the Constitutional Court already now for 2 months. And I think I recognize that the roles are different whilst they're complementary, and that there's and that whilst I can bring in that depth, as I've tried to suggest, that understanding of substantive issues, I'm not going to be writing books and developing theories in judgments which would be inappropriate to do so. So I think that there is a sort of balance that needs to be struck in some ways, but also that restraint is part of the nature of being a judge. It's a restraint that I've also tried to exercise here in some questions which have been asked to me. I was freer to say things before I'm an acting judge at the moment. And so I think that is something that, as I said, I see. I've also, I should say, written in various fora. I've written newspaper articles, blogs. I've written journal articles and books.
Try and be succinct, Prof.
Sorry, Chief Justice. I was just trying to say that I've expressed myself in different ways, and so I try and adapt my writing to the constraints of what's required by the institution.
Fair enough. My second and last question. Now, Professor there asked you a question about section 167 sub 3. Mm-hmm. I need to ask you for your comment on 167(6) that deals with direct access.
Right.
No, don't worry about it. 167(6) gives litigants direct access to the Constitutional Court and provides for requirements, right? So it says that if you are to go directly to the Constitutional Court, there are requirements that you've got to meet, and the applicant would need to satisfy those requirements in the affidavit, right? But you need direct access to sit in the Constitutional Court, right? And you are relying on 1745?
45, yes.
Yes. Now, with 167(6), if you don't meet the requirements, that's the end of the matter, right? With 1745, what happens if you don't meet the requirements? Because you've got to be assessed on your appropriateness and fitness and the tools to help this commission, judgments, and those kind of things. How are we going to be able to assess whether you qualify for direct access?
Well, I'm a different candidate from the other candidates, and so as I've mentioned, the assessment has to take place on the basis of my record. And I suppose one of the questions for which I don't want to presume to answer, but one of the questions for the Commission is, if you consider that academics can be appointed directly to the Constitutional Court without prior judicial experience, what are the criteria we're going to use to assess those academics? And I've suggested to you that some of the reasons that I think academics may be appropriate for direct, as you say, direct access or direct appointment to the Constitutional Court. And I think one would need to assess, does the person meet those requirements? Have they got a body of work that shows the required depth, that shows the required breadth? Do they teach? Do they engage with students from a range of backgrounds? The kinds of reasons that I've suggested, these are the kinds of criteria that one would need to look at and say, well, does he meet these kinds of criteria? And because of course, it's possible the Commission will decide that that's not a possible route. But if this is a route, then there needs to be criteria. And then the question is, do I meet those various criteria as a result? Thank you.
Thank you, CJ.
Thank you very much.
CJ.
That was the last.
I just want to make a correction I thought my brother will make.
Yeah, okay.
His surname is not Mangena, it's Mangena.
Hey, thank you, Commissioner. When I said it, I wanted to say I'm hoping I've got it right, because I know there's a difference. I think that
CJ,
some of us
CJ?
who come from KZN are said to pronounce it in a certain way. So I apologize. But Commissioner Malema, just say it again.
Mangena.
Mangena, okay. Thank you. Okay,
CJ, I'm sorry. There's one adverse issue that has been raised by the law bodies that hasn't been put to Professor
Okay,
Bilchitz.
yes, thank you.
Professor Bilchitz, I think largely commissioners have put to you most of the adverse comments raised by law bodies. There is one comment that hasn't been dealt with. It was raised by Nadell. And they point out that you indicate in your application that you, according to them, appear occasionally in court, but that you are on the non-practicing role. Now, I looked at your application. I didn't see you say that you appear in court. I think you did it as a candidate attorney many years ago. But you do say in your application that you do opinion work. And I think the question is whether or not you're entitled to do that kind of work if you're on the non-practicing role.
Yeah, I said specifically that I did not appear in court, I think, in the application. So I have not violated any of the law or rules of the law. I think the key issue is I've been involved in brewing litigation. That's what I meant in engaging with, as I say, questions of socioeconomic rights, providing input to attorneys and advocates about those questions. As I understand it, there's no prohibition of an academic being engaged about their views in relation to whether a case has the prospects of success or not, and whether or not this would be a good case to put forward or not. I've also done some of that in relation to my work in relation to animals, and in fact, I'm an applicant on one case. So, but I'm not a representative. So, as far as I understand, that is not something that academics have ever been prohibited from doing. I have never sought. I initially did think I might balance an academic career with a practice career, but I realized, and apart from some very exceptional individuals, I don't think they're entirely cognate, because I think academics need that time that I've tried to mention to develop those deeper theories and writings. And so that's the extent of the work that I've done.
Thank you, Chief Justice.
Thank you very much. Thank you very much, Prof. We have come to the end of the interview. Once again, thank you very much for availing yourself for this interview. We appreciate it. Thank you very much. You are now excused.
Thank you very much, Chief Justice, and thank you to the commissioners.